Good morning. Welcome to this meeting of the California Privacy Protection Agency Board. I'm going to do a quick sound check. Ms. Marzian, is that all right? Okay, wonderful. It's May 1st, 2025. We are meeting in Sacramento today. I'm pleased to be here in person with the board and members of the public and to welcome many of you via Zoom. Before we get started with the substance of the meeting, I have some logistical announcements. First, I'd like everyone to please check that your microphone is muted when you're not speaking. Second, I'd like to ask everyone who's here in person to turn off or silence their cell phones, as I'm doing right now, to avoid interruption. Thank you for doing that. And third, importantly, this meeting is being recorded. As you may know, our temporary ability to meet remotely and still comply with Bagley-Keene has become limited. Therefore, this meeting is in a hybrid format, and my fellow board members and members of the CPPA staff are here in person, and I know most members of the public are joining remotely. The hybrid format does create technical complexities, so if we have any technical kinks during the meeting, we will pause the meeting to address the issue. Today's board meeting is physically being held at the Cannabis Control Appeals Panel hearing room in Sacramento. We appreciate the CCAP team for their hospitality. All right, now I'll talk about logistics and meeting participation. Today's meeting will be run according to the Bagley-Keene Open Meeting Act as required by law. We will proceed with topics on the agenda, which is available as a handout here in Sacramento and on the CPPA website. Materials for the meeting are also available as handouts here and on the CPPA website under the entry for today's meeting. You may notice that board members are accessing their laptops, phones, or other devices during the meeting. We are using these devices solely to access board meeting materials. After each agenda item, there will be an opportunity for questions and discussion by board members, and I will also ask for public comment on each agenda item. Each speaker will be limited to 3 minutes per agenda item. We will also have a designated time on the agenda for general public comment, which is number 6 today. If you are attending via Zoom and you wish to speak on an item, please wait until I call for public comments on that item and then allow staff to prepare for Zoom public comment. Then please use the raise your hand function, which is in the reaction feature at the bottom of your Zoom screen. If you wish to speak on an item and you are joining by phone, please press *9 on your phone to show the moderator that you are raising your hand. Our moderator will call your name when it is your turn and request that you unmute yourself for comment at that time. Those using the webinar and those dialing by phone can press *6. So *9 to raise your hand, *6 to unmute. When your comment is completed, the moderator will mute you. Please note that the board will not be able to see you, only hear your voice. Thus, it is helpful if you identify yourself, but we are the privacy agency, and this is an entirely voluntary choice on your part. You can also input a pseudonym when you log into the Zoom meeting. If you're attending in person and you wish to speak on an item, please wait for me to call for public comment and then move toward the podium, which is to my right today, to form a line. You will be called on in your turn. As with the Zoom attendees, it's always helpful if you identify yourself when you begin speaking, but again, this is entirely voluntary and you, of course, may use a pseudonym or not give a name at all. Please speak into the microphone so that everyone participating remotely can hear you, and your remarks will be recorded for the meeting record. The podium microphones can be a little temperamental, so please be sure to speak directly into them. I'd like to thank our moderator, Serena Marzian, for managing the technical aspects of today's meeting and being our moderator today. Second, given that the hybrid meeting format can be a little bit finicky, I want to be sure that everyone knows what to do if any of you attending remotely experience any issue with the remote meeting. For example, if the audio drops off or the video drops off. If something happens, please email info@cppa.ca.gov. That is I for I, N for Nancy, F for Frank, O @cppa.ca.gov. This will be monitored throughout the meeting. If there's an issue that is affecting the meeting, we'll pause to let our technical staff work on the issue. The board welcomes public comments on every item on the agenda, and it is the board's intent to ask for public comment prior to voting on any agenda item. If for some reason I forget to ask for public comments on any agenda item and you wish to speak on that item, please let us know by using the raise your hand function or just raising your hand if you're here in person, and the moderator will recognize you. Important to note, each speaker will be limited to 3 minutes per agenda item for public comments. And if you are speaking on an agenda item, Bagley-Keene requires that both board members and members of the public must contain their comments to that agenda item. And we may discuss only agendized items. There is the extra sort of accommodation for the public on the agenda item for public comment on items not on the agenda today. That's number 6 for today again. And we also have an item designated for bringing up potential future agenda items. So thank you for your attention to the parameters set for us by Bagley-Keene. We will take breaks as needed today, including one for lunch. I will announce each break and when we plan to return, or at least give a range so that members of the public can leave and come back if they wish before we begin again. Please note that the 8th item today is a closed session item. The board will, I will notify the public when we take up that item, and the board will go into closed session. And when we return, we will, the meeting will remain open, but we will come back when we are done with that item. My many thanks to the board members for their service and everyone who's working today to make this meeting possible. I'd also like to thank Executive Director Tom Kemp and Mr. Philip Laird, General Counsel, who's our meeting counsel today, and again, our moderator, Ms. Serena Marzian, whom I will now ask to please conduct the roll call.
Yes. All right. Board Member Liebert.
Here.
Board Member McTaggart.
Here.
Board Member Nonnicki.
Here.
Board Member Worth.
Here.
Chair Urban.
Here.
Madam Chair, you have 5 present members and no absences.
Thank you, Ms. Marzian. The board has established a quorum. I would like to remind board members that we will take a roll call vote on any action items we vote on today. With that, we'll move to agenda item number 2, which is an item for chairperson and executive director's updates. I have a few updates, and I believe our executive director does as well. Wonderful. Welcome, Mr. Kemp. I'm excited to highlight an announcement that came out on our media, social media earlier this week, which is after many efforts and long-standing conversations by staff, including our previous executive director, the California Privacy Protection Agency, and the UK Information Commissioner's Office have signed a declaration of cooperation to strengthen cross-border privacy enforcement and knowledge sharing. The agreement allows the 2 agencies to conduct research and education together, to share best practices, to host collaborative meetings and exchange insights, and develop mechanisms for mutual cooperation. I've said this multiple times, but it bears saying again that I am, oh, mic closer. Okay. It's okay, you can just yell it out. Is that better? Okay. I hope I haven't buried this very exciting news by not speaking into the mic. That I am incredibly proud of the agency and all of our partners for the continued and growing cooperation on consumer privacy issues across many jurisdictions. Our statute both empowers and directs us to engage in this cooperation, and this is another wonderful example of that work. I'd also like to highlight the fact that next week is Public Service Recognition Week. This is an annual California tradition to honor the dedicated individuals who serve all of our communities as federal, state, county, and local government employees, particularly in today's political climate. I think that it's important that we take the time to recognize the incredible service of our public servants, their dedication, their skill, and everything that they do to improve the lives of others every day. At CPPA specifically, we are lucky to have an incredibly talented and dedicated staff, which has shown its commitment to protecting and promoting California's privacy rights, to providing information and guidance to the regulated community, and to their skill and creativity and steadfastness in this work. So on behalf of the CPPA board, I want to extend our heartfelt thanks and recognition to the public servants at our agency and across government. Your work truly matters. Thank you for your service, dedication, and everything that you do. I have one final announcement, which is related to our welcome of our new executive director. In our last meeting, the board held a closed session to discuss and possibly take action on the appointment of an executive director and chief privacy auditor on May 6th and 7th, 2025, under Authority of Government Code 11126A1. And the board voted, as it will probably be obvious, to offer the executive director position to Tom Kemp by a vote of 4-1. And with that, those are my announcements. Mr. Kemp, I'll turn it over to you.
Thank you. Thank you, Chair Urban, and thank you to the board for selecting me for this position. I'm deeply humbled to serve the people of California in this role. I would like to thank the agency staff for their warm welcome and helping me to get up to speed. Special thanks to Chief Deputy Director Garcia for her guidance, and I'm very fortunate to be joining such a competent and effective team. I want to briefly give an update on recent agency announcements and activity and provide some context behind these actions. First, the agency continues to be very much focused on helping Californians operationalize their privacy rights. As Professor Daniel Salov has noted, in California and in other states, consumer privacy is based on an individual control model that aims to empower individuals with rights to help them control the collection, use, and disclosure of their data. Californians have the strongest privacy rights in the US, but individuals often lack the time and expertise to make difficult decisions about privacy, and rights cannot practically be exercised at scale given the thousands of organizations that process people's data. The CPPA is focused on addressing this issue. First, as it relates to third-party data, we are continuing to build the delete, request, and opt-out platform, also known as the DROP system, that will go live next year. We would like to thank the California Department of Technology for their partnership in building the system. This will provide a one-stop portal to enable deletion and opt-outs from hundreds of data brokers. As you recall, at the March meeting, the board approved the formal rulemaking process with respect to draft regulations that will implement the drop. To that end, I am pleased to announce that we opened formal rulemaking last Friday, April 25th. The public comment period will run until June 10th, on which date the agency will also hold a public hearing to receive oral comments about the proposed regulations. The hearing will run from 1 to 3 p.m. and will be conducted in a hybrid format. Members of the public may attend the meeting in person at the Cannabis Control Appeals Panel hearing room located at 400 R Street, Suite 330 in Sacramento, or virtually via Zoom. In terms of funding, the governor's proposed budget for fiscal year 2025-26 includes 3 budget change proposals for the CPPA, specifically requesting additional resources for facilities, enforcement infrastructure, and DROP. All requests are currently moving through the budget process. 2 of our deputy directors, Ms. Chidimbera and Ms. Mahoney, testified in support of these proposals before the Assembly Budget Committee number 5 on March 18th and the Senate Budget and Fiscal Review Subcommittee number 4 on April 3rd. We are optimistic that these proposals will be approved and remain committed to seeing them through final approval. As it relates to first-party data, as Ms. Mahoney will talk about in a few minutes, we are the sponsors of Assembly Member Lowenthal's AB 566. This bill makes it easier for consumers to exercise their privacy rights by requiring browsers and mobile operating systems to include a setting that allows users to exercise their existing privacy rights to opt out of the sale and sharing of personal information through opt-out preference signals. The bill is similar to the bill the governor vetoed last year, but there has been a dramatic change that occurred over the last few months in terms of invasive consumer tracking that makes passage of this bill even more critical. Specifically, a large advertising platform has updated its policies to allow its ad partners to use digital fingerprinting technologies to identify users and collect information about them. Fingerprinting allows businesses to collect information about a device's hardware or software, which can be easily combined with other data to uniquely identify a user, which means that having an opt-out preference signal available on all platforms is even more critical than ever, as blocking third-party cookies is no longer a viable option with respect to reduce the impact of digital fingerprinting. Next, the agency is laser focused on addressing Californians' real-world privacy harms, including the misuse of personal information about their health, location, kids, identity, and more. This is why we've partnered with 8 other state regulators to collaborate on the implementation and enforcement of our respective privacy laws with the shared goal of protecting consumers. The consortium of privacy regulators is a bipartisan effort that includes state attorney generals and the California Privacy Protection Agency. As Chair Urban also mentioned, we've also partnered with the UK's ICO to share best practices, building upon the partnerships with the data protection authorities in France and Korea. All these collaborations allow us, the CPPA, to better protect the privacy of Californians. Finally, we've been spending a lot of time listening and learning from stakeholders. We will continue to listen to stakeholders and strive to strike the right balance between enabling the most robust privacy protections for all Californians and innovation so that California has the best of both. Thank you.
Thank you, Mr. Kemp. Are there questions or comments from board members? Mr. Liebert, please go ahead.
Thank you very, very much for those comments. And I was intrigued with your update about the state of cookies and the ability of consumers to try to protect their privacy. I just want to reiterate my own view that our current privacy model requiring consumers to try to protect their data is clearly not working, never has worked, and is totally unreasonable. And so the board's efforts here to work hard to try to address that problem is like swimming upstream, but we have to keep swimming. And I'm very pleased to hear about the efforts that we're doing to work with other countries to try to figure this conundrum out. The way the basic ad system for funding the internet clearly has never protected consumer data. We all know it's more at risk now than it ever has been. So I want to congratulate the staff for all the work that they're doing, and thank you for that update.
Thank you.
Thank you, Mr. Liebert. All right, well, thank you very much, Mr. Kemp. That's an impressive array of activities by the agency staff, and which we have become accustomed to, but we do realize how lucky we are and how lucky the state of California is to have this amazing skill set and dedication on the staff. So thank you for that. Is there public comment?
If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 2, Chairperson and Executive Director's update. Madam Chair, it looks like we have a few commenters.
Great, thank you.
Nisha Patel, I'm going to unmute you at this time. You'll have 3 minutes to make your comment, so please begin as soon as you are ready. Nisha Patel.
Sorry, no comment.
We have a JAAKKO. Go ahead and speak.
Nope. Looks like you took your hand down as well.
Once again,
if you'd like to
make
make
a
comments on agenda item number 2, please raise your hand using the raise hand feature or by pressing star 9 if you're joining us by phone.
Madam Chair, I'm not seeing any other hands raised at this time.
All right, thank you very much, Ms. Marzian. With that, we will move to agenda item number 3, which is a legislative update and potential authorization of California Privacy Protection Agency positions on pending legislation. And that will be presented by our Deputy Director of Policy and Legislation, Ms. Maureen Mahoney. Please turn your attention to the materials provided for this agenda item. I believe Ms. Mahoney will present the slides and will request our questions and comments where it makes sense in the course of the presentation because there are multiple things to consider. Great, thank you. Please go ahead.
Thank you, Chairperson Urban, board members. I appreciate the opportunity to provide an update on our legislative work. And I am getting over a cold, so if I do get a coughing fit, please bear with me. For this item, I'll do several things. First, I'll provide an update on our engagement at the federal level. Then I'll provide a very high-level overview of some of the privacy and automated decision-making technology bills that we're monitoring in states across the country. Then I'll turn to California. I'll give a brief update on the CPPA-sponsored bill, AB 566, on opt-out preference signals. Then I'll provide an update on several privacy and tech bills in California that we're watching, but we're not recommending that the board take a formal position on. And then at the end, I'll present for board consideration recommended positions on 5 California bills that specifically amend the CCPA, the DELETE Act, or direct the agency to act. So after each of these sections, I'll pause for comments and feedback from the board. So first, I'll turn to our engagement at the federal level. So we are continuing to see interest on the federal level in comprehensive privacy legislation, particularly in the House of Representatives, although at this point, a new draft has not yet been circulated. So in this area, the House Energy and Commerce Committee has created a working group, including only members of the majority party, and they're exploring and developing a new framework for federal privacy legislation. So going back to the drawing board, as it were, they issued a request for information to hear from stakeholders about key priorities, existing models in other jurisdictions. Those comments were due April 3rd. The agency did submit comments urging Congress to establish a strong federal floor of protections while allowing the states the ability to go further, consistent with the agency's position. The New Jersey Attorney General joined us, signed on to the letter we submitted. In terms of next steps, we're hearing that we may see draft language on a privacy bill later this year from House E&C. Although it could be sooner, it depends on their process. So we are hearing fall, but it could be earlier. We're also hearing the kids' privacy legislation may move separately, so we could see that even earlier. For example, COPA 2.0 has already been reintroduced in the Senate, but not yet in the House and has not yet been considered by the relevant policy committees. We've also been monitoring a notice of proposed rulemaking from the Consumer Financial Protection Bureau that amends the Fair Credit Reporting Act rules to make certain types of data brokers subject to that law. So we submitted a public comment that explained how the DELETE Act regulates data brokers, how it aligns with and operates alongside the Fair Credit Reporting Act. And we're continuing to monitor a wide variety of federal bills focusing on privacy, children's rights, and artificial intelligence. Next is a high-level overview of what we're seeing in the state level across the country. So as you well know, and as the chairperson mentioned, the CCPA directs our agency to work with privacy authorities across jurisdictions to work towards consistency and privacy protections where possible. So we monitor privacy legislation and we engage where appropriate. So this year, 18 states introduced comprehensive privacy bills. So that's on top of the approximately 20 states, including us, that have already adopted comprehensive privacy laws. Several sessions have early session deadlines, so we know that already 7 of those did not pass, but 7 states still have active bills, so we may see more states come online with privacy laws this year. There have also been Delete Style Act bills introduced in 3 states, so again, a trend in terms of folks looking to California to see where the leading edge in privacy is. So it's Illinois, Nebraska, and Vermont, only one of which, Nebraska, is still currently active. And then ADMT remains a very active space around the country. We've been monitoring the comprehensive ADMT bills. 12 states have introduced such bills, 5 of which have already died, so 7 are still pending. So again, a lot of activity in this space. And I'll pause here before moving to California.
Questions from board members? Yeah, sorry, I can't turn my head off. Just wave.
Thanks, Ms. Mahoney. Just can you give me a sense of your opinion on the 18 bills and the 3 and the 12? How many of them are good and how many of them are not good? Just rough.
In general, we're seeing a trend towards states kind of ratcheting up the privacy protections, encouraged by states like Alabama having bills with a global opt-out. In terms of good bills versus bad bills, out of the 11 that are still pending, I would say 7 are good and in trying to move the needle forward and at least have some sort of global opt-out.
Dr. Nanaki?
Thank you. Out of the bills that are still remaining, are they in alignment with our law in California, or is there a misalignment?
That's a good question. I would say that the similarities are overwhelming in the sense that all of them provide the same baseline privacy protections in terms of access, deletion, some form of stopping the transfer of information. Some of them go even further with really strict data minimization. Some of them, maybe have broader exemptions for federal laws, definitions that are not quite as comprehensive. So I'd say that they follow the same general trend, but some are a little stronger and a little weaker.
Sorry to put you on the spot, but on the ADMT bills, is the approach similar to the bills we're seeing in the California legislature or to our bill? Ours is fairly limited in its language, but that we need to implement the regulations, of course, or Colorado's. Is there a model emerging, or are they quite different?
Well, I'll caveat it in saying that there are many, many AI bills that are out there. We've been focused on the comprehensive ADMT bills, which is where a lot of the focus has been. And I would say that there is a framework that is developing, very similar to the Colorado AI Act, similar to the bills we're seeing in the California legislature in terms of Rebecca Bauer-Cahan's AB 1018 and Senator Padilla's SB 420, which I'll talk about a little bit more, but a focus on trying to avoid algorithmic discrimination, some form of notice, and opt-out or appeal.
Thank you. And the CFPB regulation rulemaking, apologies for my lack of memory here. Was that, did that begin before or after the administration changed over?
It began before. They've been working on it for, maybe a year or two, but they continued to keep the comment period open as the administration turned over.
Thank you.
curious as to whether or not there are any employees left at the agency to continue that work. Do we know whether those folks are still there?
My understanding is this is a very unstable situation, but that it's a very small percentage of folks that are still around at this point.
Thank you, Ms. Mahoney. Additional questions? All right. Is there public comment? Oh no, let's do public comment. I apologize. You have more to go. Thank you, Ms. Mahoney. Go ahead.
Okay, so now I'll move on to the California bills. To give you a sense of where we are in the legislative process, it's still relatively early on. Tomorrow is a key deadline. So tomorrow's the deadline for bills that are keyed fiscal to be reported out of the policy committees in the first house. The non-fiscal bills have until May 9th to get reported out of policy committee. And then the fiscal bills have to get out of appropriations by May 23rd. So that'll be a key point. June 8th is a deadline for each house to pass bills introduced in that chamber and send them over to the other chambers. So that's the crossover deadline. The committee process is then repeated in the opposing chambers. September 12th is a deadline for bills to clear the legislature, and then the governor will have until October 12th to sign, veto, or allow to become law. And I want to start with an update on AB 566, authored by Assemblymember Lowenthal, our opt-out preference signal bill that CPPA is sponsoring, that Mr. Kemp just gave a great update on. So as you know, these opt-out preference signals are so important in giving consumers a one-step way of stopping the sale and sharing of their personal information with all businesses they interact with online. A few privacy-focused browsers have offered these tools, but the biggest ones don't offer support for them. Furthermore, the major browsers on mobile platforms don't even allow extensions to be added to them, so you can't even use a third-party plugin on mobile, and there's no opt-out preference signal for apps. AB 566 addresses this problem by requiring browsers and mobile operating systems to offer these signals. Since the bill has been introduced, staff in the author's office have worked to expand support for the bill beyond privacy groups per the board's direction. The bill does have new supporters such as Common Sense Media and Mozilla, and will continue to work to get more support. Staff has also worked with the author to engage stakeholders early on and is working to find ways to address the opposition's concerns. So in terms of where the bill is, it's advanced out of Assembly Privacy and Assembly Appropriations, so it's eligible for a floor vote in the House of Origin, which hopefully will happen at some point in the next few weeks. Next, I'm going to provide brief updates on a selection of bills that we're watching because they're relevant to the agency's work, but we're not recommending that the board take a position on them because they don't affect the CPPA. They don't amend the CCPA or the Delete Act or direct the agency to act, with the exception of one, which I'll talk about. And I'm going to start with several ADMT and surveillance bills that we flagged because they potentially overlap with the proposed ADMT and risk assessment regulations and the CCPA statute itself. These bills generally fall into two categories, ADMT and employment surveillance. Also discuss an insurance bill that has relevance with respect to our proposed regulations pertaining to insurance companies. And then I'll conclude with a bill that regulates foreign information transfers. So turning first to the ADMT-related bills, to save time, I just want to note at a high level that these ADMT and employment surveillance bills I'm about to discuss, it appears that there's some overlap with our regs under the CCPA in its current form, but they all build on and go further than what the proposed regs do. So starting with AB 1018 from Assemblymember Bauer-Kahan on automated decision systems. So this bill is a modified version of AB 2930 from the same author that we followed closely last year. It governs automated decision systems used to make consequential decisions, but with a broader definition than in our proposed regs. It requires performance evaluations, pre and post-use disclosures when using automated decision systems for consequential decisions, allows individuals to opt out, correct the information, and appeal the decisions. It doesn't implicate the CPPA. The bill is enforced by a number of entities, including the AG, the Civil Rights Department, and the Labor Commissioner. And it does have an interesting provision specifying that businesses subject to the CCPA are also subject to, the CPPA regulations as well as the requirements of this bill. There's a similar bill offered by Senator Padilla, SB 420 on automated decision systems. This regulates high-risk automated decision systems, requires impact assessments, notice when automated decision systems are used for decision making, and when feasible, allowing individuals the right to appeal the decision with human review. Next is SB 7 from Senator McNerney. This bill specifically regulates the use of automated decision systems in the employment context. Employees are granted rights to access, correct the information used to appeal the decision, and there's a notice requirement as well. The bill also has additional requirements, such as that hiring, promotion, discipline, and termination decisions can't rely primarily on automated decision systems. Again, the CPPA doesn't have a role with respect to this bill. It's enforced by the Labor Commissioner and has a private right of action. Then we have AB 1064 from Assemblymember Bauer-Cahan. This bill establishes a regulatory framework for AI products targeted to children. It creates the Lead for Kids Standards Board within GovOps, which is in the governor's office, to oversee and regulate AI systems that are used by or on children. So it requires developers of these AI products that are targeted to kids to register the product with the board, perform a risk level assessment. The bill notably also requires affirmative consent before a kid's personal information can be used to train an AI system. Again, CPPA does not have a role with respect to this bill. Then we have AB 1221 from Assemblymember Bryan. This has to do with workplace surveillance tools, and it requires employers to notify employees if there are surveillance tools that are used in the workplace to collect employee data. Employees have the right to access, correct the data, and then there are additional provisions that go further than the CCPA in terms of prohibiting the transferring or selling of any employee data to third parties. Again, CPPA doesn't have a role in this bill. It's enforced by the Labor Commissioner and a private right of action. Great. So moving on a little bit from the ADMT and workplace surveillance bills, there's an insurance bill, SB 354 from Senator Lamont. So as you know, the CCPA directs our agency to review the privacy requirements established by California's insurance code, develop regulations that would apply the CCPA to insurance companies only to the extent that the CCPA provides greater protections. So we're monitoring this bill because it establishes new regulations for insurance entities, and it creates a comprehensive framework. In its current form, in staff's view, the insurance bill has equal or stronger privacy provisions than the CCPA and would likely negate our need to adopt additional regulations beyond the current work to specifically address insurance companies. So it establishes standards with respect to the processing of personal information by insurance licensees, the third-party insurance providers providing right to know, correct, deletion. It also requires consumer consent to use personal information for non-insurance related purposes, for marketing purposes, or even for sharing information. So it's an opt-in framework, and it's enforced by the insurance commissioner and by private right of action. Great. And then finally, in terms of our watch bills, we have AB 364 from Assemblymember DeMaio. It does amend the CCPA. The core provision is that it requires businesses to notify consumers and get their consent if the business is going to hold their personal information outside the US. So staff recommends not taking a formal position on this bill, even though it does amend the CCPA. It's primarily focused on national security concerns related to information transfers that in staff's view is best handled and considered by the legislature. Furthermore, the bill looks likely to miss the deadline to move out of committee. So unless I'm reading the rules wrong, it does not look likely to advance this year. So I'll pause here in case the board has any questions on these watch bills.
Wonderful, thank you. Thank you, Ms. Mahoney. So I appreciate the prediction on AB 364 and certainly trust your judgment on that. What is the enforcement mechanism?
For AB 364? Well, it amends the CCPA, so it would.
Oh, it would be the
yeah.
same as all of the rest, of course, and it doesn't, because some of these, like the insurance bill amends the CCPA, but it's unclear exactly what our place would be. I mean, I really, anyway, it's a longer conversation, but okay, so that's helpful. I'm just going to go up. So AB on the presentation, AB 1221. Do you have any examples of what a surveillance tool might be?
Well, that could be, cameras in the workplace, maybe keystroke logging, things like that.
Okay, good, thank you. And then on Senator SB 420, Senator Padilla's bill, what is a high-risk automated decision system? And in general, you can imagine I'm probably just curious about whether that's in alignment with how other states have approached this, or if it isn't.
Yeah, so that is using, in my read, it's using the definition that already exists in the California Code that regulates government use
Right.
of automated decision systems. So that's automated decision systems used to assist or replace human discretionary decisions that have a legal or similarly significant effect.
Okay, thank you very much. All right, questions from other folks? Mr. Worth, and then Dr. Nonike.
Thanks for that presentation. I had a few questions. I mean, just in general, we talk about the overlap, right? I mean, some actually amend the CCPA. Some are just have a different set of rules than maybe we have. How are we going to deal with that going forward? And from our perspective, I'm thinking about the businesses. How do they know where to go to find the rules to operate a business in California? So maybe first, kind of from our perspective, how do we feel about another set of rules that technically kind of amend what we've put out? How do we operate an agency with that impact?
Yeah, that's a good question. And I think one that everyone is kind of struggling with when they're thinking about how to advance stronger privacy protections. I do think it's probably best to just amend the CCPA if you want to go further, because then it's easier to see how things line up. Oftentimes, privacy or other bills end up in different parts of the California Code. And like you said, folks aren't as aware to look there, and then it's harder to see how things line up. Sometimes people are incentivized to write things in a different part of the code because they don't have to deal with our exemptions for publicly available information, or to use our definitions. It can be easier just to do that, but it does take additional work to kind of analyze how they intersect. But it's not uncommon for there to be new privacy laws that have some overlap but go beyond what we do. And in fact, that was anticipated by Proposition 24, which explicitly states that CCPA should set a floor and allow stronger protections in terms of our regulations, in terms of overlap with what we're doing whilst things are still in flux with our regulations. I would say, again, I don't see anything wrong with the legislature wanting to go further than what we're trying to do. Ultimately, it's up to the board, but I would say that from staff's perspective, if any of these bills are passed, we would do what we can to to review them, update the regulations to make sure that everything's consistent.
Okay, so we wouldn't set the floor and keep our regulations at a certain place. We would adjust, like the insurance code you mentioned, we would adjust as things come at us. Hopefully things that we are in alignment with and agree with that come at us, right? I mean,
I think the legislature is in a better position to go further because they can make statutory changes, but we would just make sure that that our regulations are consistent and that everything, that businesses can comply with both.
okay. And then how about on the enforcement for a minute? There's like a pretty long list of different groups that would be responsible for enforcement. That sounds like a really bad model. How does that impact us? And is there anything we're going to do, or do we just have to let that be what it is?
Again, that's a good question. I think from a consistency standpoint, it would be ideal if the agency had enforcement authority over these bills where there is overlap with what we're already doing to make sure that our enforcement activity, can be consistent. All the enforcement activity can be consistent across statutes. We do work to provide technical assistance to make authors know that we're out here, what we're doing. It would be helpful to me if there were board guidance, to say it's okay as part of technical assistance for me to say, with some of these bills, we think it might make sense for the CPPA to enforce.
Yeah, I was just trying to get that on the record. And finally, what I'm hopeful is that as we get our rules adopted, that maybe others will see less of a need to get ahead of it and will rely on this agency to do its work.
Thank you, Mr. Worth. Dr. Nanaki, please go ahead.
Great, thank you. And thank you so much for the of all of these bills. I have a couple of questions. Quite a few of the bills have within them obligations for impact assessments. I would love to hear your thoughts on how that is being structured within the bills. And I also wanted to flag another bill. It's too far away. I want to flag another bill from Senator McNerney, SB 813, which would establish this multi-stakeholder panel to be able to provide guidance on what does an adequate impact assessment look like. So if you could talk a little bit about that impact assessment process and also McNerney's bill.
Sure. So I would say it would definitely be fact specific with respect to the bill. Our risk assessments are more focused on the information that's being used to train these systems or implicated by these systems, whereas the risk assessments for some of the other bills are more targeted towards what the goal is. So, for example, the automated decision system bills I talked about are focused on identifying algorithmic discrimination and eliminating those issues. And again, our regulations are somewhat in flux. So I'll have to provide more information and give it a closer look. And then in terms of SB 813, we've been tracking the bill, but I haven't analyzed it closely.
Yeah, thank you so much. And then just one final comment. Because they're high-risk settings, I would say they are predominantly using personal information. That's why there's the trigger for high risk. So there is significant overlap with the work that we're doing.
Thank you, Dr. Nanaki. Board Member Liebert.
Well, I want to thank my fellow board member, Mr. Worthy, to raise that question about somewhat the elephant in the room. And the elephant in the room for our agency right now is that the agency has been the subject of a lot of criticism, obviously, in the last year plus, that somehow we have been traveling over our skis, if you will, on our ADMT and other regulations. And obviously, we have been listening very carefully to that criticism and concern by some parties and doing our very best to try to strike the best balance we can with the work that we're doing, always being vigilant about our instructions from our founding parents about Prop 24 and the importance to try to protect California's privacy interests. And in that regard, we obviously still have some work to do in the legislature and with our friends across the street. I'm glad we're here today because we care very much what they're doing and what they're thinking about these things. And I think that if we can continue in the work that we're doing in a really effective way, it obviously, Mr. Worthy should land at a place where this agency is the one that should be engaged in a lot of these enforcement efforts. We've got an incredible team of enforcers with expertise to do this type of work. These other agencies that are currently being listed in bills often have no structure to do this type of work and no history and no expertise per se on the types of issues they may be tasked with. So I'm very encouraged and hopeful that the great work that we're doing right now in trying to strike that balance is going to ultimately demonstrate to our friends in the legislature and in the governor's office and other very important folks who we're trying to work with here that we're really doing our best to strike these balances, and we really are the natural place for so much of the work and the important consumer protection work that's being discussed now for the state. So I hope we make that progress.
Thank you, Mr. Lieber. Mr. McTaggart?
Thank you, Ms. Mahoney, for a great update and very comprehensive overview. I'm wondering, and I can talk to you about it offline if you're not, but have you been following at all SB 690, the attempt to amend the Invasion of Privacy Act, but for the commercial purposes?
Yes, we've been monitoring that bill. Did not include this one in this presentation since it doesn't specifically affect the CCPA.
And do you just give us your thoughts about it? Because I've had people talk to me, and at first blush when I look at it, I think, I'm not sure we would support it, but what are your thoughts on it?
I'd actually prefer to have that conversation offline.
Thank you, Mr. McTaggart. Thank you very much, Ms. Mahoney, for, as ever, a tour de force tour through some very complicated territory. Please go ahead.
Okay, well, we have more to go. So for the final portion of the presentation, we'll go through 5 bills that directly affect the agency. They either amend the CCPA or the Delete Act or specifically task the agency to act. And these are all bills that we've recommended that the board take a formal position on. So for time, I'll highlight the key provisions of these bills and staff recommendation for each, and then turn it back to the chair for discussion at the end. So first is AB 1355 from Assemblymember Ward, having to do with location privacy. Staff recommends a support position on this bill because it affects the agency and meaningfully advances consumer privacy. This bill prohibits covered entities from collecting or processing more location information than what's necessary to provide the service requested by the consumer, and it prohibits the sale of such information to third parties. It's enforced by the Attorney General, district attorneys, and our agency. And we think this bill is important because location data collected from public surveillance technologies like cameras, like automated license plate readers, can create a detailed profile of consumers' individual movements. It exposes deeply personal information about healthcare visits, religious practices, and political activities. It's consistent with the CCPA. And the geolocation data is already classified as sensitive personal information under the CCPA and subject to greater protections, but this bill will go even further. And then by including our agencies as an enforcement authority, it allows us to provide critical support for these new protections. Next, we have SB 4.
Sorry,
Oh, yeah.
I just have a quick clarifying question. I got lost in the color coding. What does this one amend?
This is actually a separate part of the code. It does not amend the CCPA,
Okay, thank you.
but they added language saying that we could enforce.
Right, okay, thank you.
Let's see, SB 44, which has to do with neural data. Staff also recommends a support position on this bill. This one actually does amend the CCPA. It requires covered businesses collecting neural data to use that neural data only for the purposes for which it was collected, and then the entity has to delete that data once that purpose is accomplished. So you'll recall we supported a bill last year to add neural data to the definition of sensitive PI in the CCPA. Companies have been experimenting with implantable brain consumer interfaces that are being developed to allow someone to use a computer solely by their brain activity, but that means that this information can provide insights not only to what someone does, but what they think. So we think additional privacy protections are appropriate, and also note that the consumer doesn't have to take action for these protections to go into effect. Let's see, next we have SB 361 from Senator Becker having to do with data broker registration. So this one amends the Delete Act. So as you know, under the Delete Act currently, data brokers have to provide certain information when they're registering, including whether or not they collect information such as reproductive health care data or kids data. This bill would expand those categories of disclosure. So specifically requiring data brokers to disclose whether they collect account login information, government ID numbers, citizenship data, including immigration status, and so on and so forth. So I think this is particularly important because it'll help consumers be more meaningfully informed when deciding whether to exercise their rights through drop. Next, we have SB 468, also from Senator Becker. This one has to do with high-risk artificial intelligence systems, the duty to protect personal information. So this is a data security bill. It requires deployers of high-risk AI systems that process personal information to implement a comprehensive information security standards. It gives our agency rulemaking authority, but not enforcement authority. So we have a support if amended recommendation, support if amended to add CPPA enforcement authority. So under the bill, these security programs must be in writing and include things like designated employee managers, detailed employee training and compliance programs, encryption, so on and so forth. Many of these elements are elements included in the proposed cybersecurity audit regulations. But given the revenue threshold on the cybersecurity audit regulations, this bill would likely cover a broader set of high-risk AI systems. So we think this bill is important because these systems collect a lot of personal information. They can be a target for hackers, and there is the threat of breach. So we think that having these clear mandated security protocols would help protect consumers' critical personal information. We also think giving the CPPA rulemaking authority, as the bill does, will help make sure that there is consistency in the obligations under both. And StaffSU, if we were granted enforcement authority, then we can more effectively ensure that businesses are meeting their obligations under the law. So that's why we recommend support if amended. Next slide, please. And now for something completely different, the last bill I'll highlight. SB 470 from Senator Laird. So that extends the existing Bagley-Keene teleconferencing requirements. So those are set to sunset January 1st, 2026. This bill would extend them to January 1st, 2030. So, as you know, the board has relied on the teleconferencing options to ensure that we can meet to consider issues in a timely manner. Most members of the public attend meetings remotely. Staff believes that fully remote meetings allow the most robust public participation, but this teleconferencing alternative allows some members to meet remotely as long as there's a quorum in person, and that therefore supports board diversity by better enabling those at a higher medical risk to serve. So that's why we recommend a support position on this bill. So I'll stop here and turn it back to the chair.
Thank you very much, Ms. Mahoney. Would you like us to proceed through the bills, or shall we start with general comments and questions?
Maybe general.
Okay, all right. Mr. Worth, did you?
I kind of went through the general stuff already. I had specifics on two of the bills whenever.
Okay, well, if that's the case, why don't we just do that?
Okay. On the last one on SB 470, in in the memo talks about we can have a quorum split amongst multiple public locations, right? If we have a quorum in one public location, can another board member, this is not self-serving, can another board member meet in a non-public, Zoom in on a non-public location?
If there's a quorum in person,
Yeah.
yes.
Okay, I don't know if that needs to be in there or not. Then I went back to AB 1355. The location do we have the 1,850 feet in our regs? We do, thank you. I always appreciate that everybody knows this stuff better than I do. There's the bill specifically states collect more things that are prohibited, collect more location information than was necessary to provide the requested goods and services. God, that sounded vague to me. Is that just me, or it feels like if they could put some more language in there to talk about exactly what they're, I was trying to come up with examples of what that means. I totally get the Uber one because I did it this morning twice, but I just don't know. Maybe we're not here to reauthor, but certainly I felt like that was too vague for me. And then if we're going to enforce this, is that what I heard? Okay. So the bill provides restrictions on what can be disclosed without a valid court order. So now this agency is going to determine if there's a valid court order or not in order to enforce this?
Well, there's a similar provision in the CCPA already. So
Okay, perfect.
That's actually standard.
Great.
Yeah.
Thank you.
I will say on the data minimization language, I think the intent is to make it restrictive enough to prevent kind of the worst abuses, but allow enough flexibility for necessary uses. So an example I heard recently is maybe location data collected by your weather app, collect only the information they need to show you the weather, but maybe not be selling your information or collecting, other things.
Okay, that's helpful. Thank you.
May I follow up on Mr. Worth's question about the data minimization? How do you see this in relation to the CCPA's data minimization requirements? I'm just thinking through his good question in my mind. Again, it's pretty standard data minimization language, but are we comfortable that it will sort of play nicely with what the CCPA has and what the regulations have? And if not, it goes a little bit further, and that's something we can be comfortable with if we decide to be, or is there something more that we might suggest to the author?
I mean, I know the bill has gone through several iterations before. I think previously it did have a consent requirement as well as the data minimization. I think that it does play nicely with our regulations, and that maybe it takes it a step further in terms of being restrictive.
Thank you. Yeah, Dr. Nanaki?
I have a question on SB 468. Within this, it defines what high-risk systems are, and to my knowledge, this only applies to developers, essentially the private sector, developing these tools. Am I right in understanding that this would not apply to the state of California itself, since it is also developing high-risk AI systems with consequential decisions in housing, education, employment, healthcare, criminal justice?
That's a good question. I don't know off the top of my head. Just businesses.
Okay. So I guess the businesses would comply if, the state of California was procuring from a third party, but my concern, anything developed internally then evades all of this.
That was 468. Sorry, I was reading. I was back. I was looking for 1355 online, and I apologize. Yeah. Yeah. Okay. And I do follow your comments on that. All right. So, and the question before us will be whether or not to accept staff's recommendation on positions on these bills. So of the ones that have been presented to us for this question, staff's recommendation is that we support all of them with the exception of SB 468, which staff recommends that we support if amended to give us enforcement authority. So I want to say at the outset that I really appreciate the legislature's attention to these issues, and when they partner with us to, to receive technical help if that's helpful, and to develop a rationalized approach across the state, as Mr. Worth was alluding to. We didn't say much about SB 44. It's very specific, of course, to neural data. I wanted to highlight the delete requirement in that law for this kind of highly sensitive data that is incredibly personal to the person. I suspect that this kind of requirement is going to become more important. Mr. Liebert alluded to the fact that California and the US generally tend to have a more opt-out focused approach that relies on consumers' actions. And as we have this more and more detailed and sensitive information, this is a step towards thinking about where that may not be as appropriate. It really stood out to me today because of the fact that a consumer genetic information company has gone into bankruptcy. And not only do they have people's genetic information, which is not something that you can in any way realistically anonymize, et cetera, they have biological samples. And in California, we actually have a law that gives people the right to tell that company to destroy the biological sample. I'm very grateful for that at the moment and on behalf of Californians, but of course their customers are not only Californians. And so it's perhaps a small point in the law, but it does seem to be a very sort of forward-thinking approach by Senator Umberg on this. With Senator Becker's bills, the DELETE Act adjustments strike me as key transparency requirements. I have found the benefit that people see in the revised data broker registry with specifics as to what kind of data is being collected to be very valuable to the public. And in today's current political climate, which is a phrase I might say more today, having a clear and transparent understanding of where some of this information is simply crucial for people's autonomy and rights. And then I'll say more about this topic when we talk about our draft cybersecurity audits. But with the security bill, SB 468, Senator Becker is, in my view, responding to an ongoing, rapidly growing, and accelerating threat. And I am pleased to see that he is approaching it from the perspective of imposing requirements for these high-risk systems. I take Dr. Nanake's point that the scope, again, in terms of to whom it applies, may be somewhat limited. I do want to say a little bit about the enforcement authority. I would absolutely support if amended for that reason. And one of those reasons is because, again, of the sort of rationalized approach, which the board has talked about a bit this morning, makes sense, but also because our enforcement arm has specific expertise. And I think that's just very valuable for those whose personal information is at risk, those whose business systems are at risk, because cybersecurity is an ecosystem problem, and for businesses who need guidance and get guidance sometimes through enforcement actions and recommendations. So everybody's heard my position on SB 470 type frameworks many times, so I won't belabor it unless Dr. Nanake really wants to hear my speech that she hasn't had a chance to hear of yet. But I just think it's crucially important to make our board meetings and service on boards and commissions accessible to Californians from all regions and all walks of life. And so while I wish it weren't this sort of a little more time and a little more time, a kind of approach, I would absolutely support it. Mr. Liebert, did you want to say something? I couldn't tell.
No, I just look friendly.
Okay.
No, I would just say that I'm actually.
You always look friendly.
Oh, good. I just want to note that I'm going to recuse myself from any of the votes on the legislative presentation.
Okay.
on those
Oh,
bills,
sorry.
So thank you.
Okay, wonderful, wonderful, thank you. All right, there is an additional item that has arisen in the colloquy between Mr. Worth and Ms. Mahoney. Thank you very much. I would certainly support crafting authority that would give our policy and ledge staff room to provide technical advice and to make decisions about support or support if amended, et cetera, on the enforcement authority piece. But I may not quite be getting what you said correctly. So please amend me if needed.
I mean, I think what you're saying is we want to house the enforcement authority, correct?
Where it makes sense, yep.
Yeah, where it makes sense. My point was the same point made the other way. What I read doesn't make sense. So let's try to tighten it up so we're on the same page.
Okay, great. Do we have any thoughts on that specifically? Okay. All right. In that case, the motion that I'm going to request to be put on the table, and then we'll take public comment, will be to authorize agency staff to support AB 1355, SB 44, SB 361, and SB 470, and to support SB 468 if SB 468 is amended to provide the agency authority to enforce its provisions. And furthermore, to authorize staff to continue to support these bills as stated, even if amended, if in the staff's discretion the amendments are consistent with the objectives set out in the memos before us today and our discussion today, and to authorize staff to remove support for or oppose these bills if amended, if in staff's discretion they're no longer consistent with those objectives set out in the materials for today or our discussion for today. And then I'm going to ask Mr. Laird if I need to add to that with regards to the enforcement piece that we were talking about.
Are we on? Okay. I don't think we do. I think
Okay.
that direction can be sort of informally provided without the vote.
Okay, well, and it seems encompassed in the direction that we usually provide. I just wanted to be sure. All right, with that, Ms. Marzian, is there public comment?
Agenda item number 3, legislative update and the authorization of CPPA positions on pending legislation. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 3. Madam Chair, I'm not seeing any hands raised at this time.
Thank you, Ms. Marzian. Any further comments, questions from the board? In that case, may I have the motion that I stated? Is someone willing to move?
So moved.
Thank you, Mr. Worth. May I have a second?
Second.
Thank you, Dr. Nanaki. Ms. Marzian, could you please conduct the roll call vote?
Board Member Liebert,
Not voting?
Board Member McTaggart,
Aye.
Board Member Naneki,
Aye.
Board Member Worth,
Aye.
Chair Urban.
Aye.
Madam Chair, you have 4 yeses and 1 not voting.
Thank you very much. The motion carries with a vote of 4-0, with Mr. Liebert recusing himself. Thanks very much to the board for the discussion. And Ms. Mahoney, thank you for what, again, is just an absolutely stellar job, being our liaison to the legislature and keeping us informed and giving us excellent advice on a welter. I don't say that in a negative way, but many complicated and overlapping bills this year. So thank you very much. Shall we move on to the ADMT cybersecurity risk assessment regulations, or do folks want a short break? Okay, we will go ahead and take a 10-minute break and return at 10:45 a.m. Thank you.
Already.
Welcome back, everyone. Thank you for joining us today. We will continue with our agenda with agenda item number 4, which covers discussion and possible action on proposed regulations regulating automated decision-making technology, risk assessments, cybersecurity audits, insurance, and updates to existing regulations, including possible modification of the text. This item will be presented by members of our legal division, CPPA General Counsel, Mr. Philip Laird, Senior Privacy Counsel and Advisor, Ms. Lisa Kim, Attorney Ms. Kristen Anderson, and Attorney Nilofer Sheikh. Thank you all for being here with us today and for the incredible amount of substantive work that you have put into this, even since the last board meeting. And Mr. Laird, please go ahead.
Thank you, Chair Urban. So today we'll be walking the board and the public through the most significant potential modifications to the proposed regulations since the board met just under 4 weeks ago in April. The proposed modifications before the board are based on the board's feedback at the April 4th meeting, as well as based on staff's review of additional public comments that were received. As a general point, where staff has proposed revisions to the regulations that potentially reduce compliance burdens and costs for businesses, and to take a more incremental approach, those modifications reflect the board's policy preferences shared during the April meeting. The board, of course, though, has the discretion to revert to more robust protections for consumers in the regulations. And to be clear, the agency has the authority to promulgate regulations that provide more robust protections for consumers' privacy, even if there is a higher cost associated with it. So again, I just want to make that point abundantly clear. Agency has authority to do everything we've been talking about today and up until this point, but at the same time, we recognize already the theme of balance that's been discussed is one for the board to consider. So today, staff is certainly happy to take any additional feedback to finalize these modifications, but does recommend that the board vote them out for a 15-day round of public comments after today's meeting. Next slide, please. So as a reminder, the agency has until November of this year, 2025, to finalize regulations, or else we would be in a position where we'd need to begin the rulemaking process over again. When I say finalizing the regulations, what I mean is submitting final adopted regulations by the board, along with all the accompanying materials that the agency has to prepare, such as a final statement of reasons, which will include responses to every public comment we've received to the Office of Administrative Law. To meet the November deadline, we do recommend that the board provide staff with feedback during today's meeting, and that we can implement and incorporate that then into modified regulatory text that then would go out for another round of public comment before we'd be in a position of actually adopting regulations. So again, to be abundantly clear, anything being changed, any of the proposed modifications shown in today's materials cannot be adopted today, will in fact receive an additional round of public comment for all of you to consider. So with that said, we do have a few slides prepared to walk you through some of these changes that appear in this text, and I'm going to turn it over to my colleagues to walk you through some of the most significant ones.
How about now? Okay, great. So the first slide that we're going to walk you through, this is about one of the potential modifications we've highlighted for the board's awareness. This is the phasing in of implementation of the cybersecurity audit regulations over time. by businesses' annual gross revenue over a 10-year period. Staff proposes this potential modification in response to the board's direction during the April meeting to find ways to significantly reduce the costs of the proposed regulations. So under option 1 on this slide, which is also what's reflected in the proposed red line text for today's meeting, businesses that meet the criteria in 7120B, which as a reminder, that's the 50% or more of your annual gross revenue from selling or sharing consumers PI, or meeting a revenue threshold and a PI processing threshold of 250,000 or more consumers or households' personal information, or 50,000 consumers plus sensitive personal information. So if you meet those criteria, you would have different amounts of time to implement the cybersecurity audit requirements by your annual gross revenue. Specifically, businesses with over 100 million in annual gross revenue would have to complete a cybersecurity audit by April 1st of 2028. Businesses with between 50 million and 100 million would have to complete their first cybersecurity audit by April 1st of 2029. And businesses with under 50 million would have to complete their first cybersecurity audit by April 1st of 2030. The proposed revisions to 7121, which is the timing requirements, also acknowledge that businesses would likely need time to provide the cybersecurity audit report after completing the audit itself. So it provides an additional 3 months after a 12-month audit period to complete that report. And it also clarifies the audit coverage period and specific date by which a business must complete the audit report. Just so you know, the double asterisks alongside the second row of the 100 million to 1 billion just indicate the differences between options 1 and 2. For option 1, that just means that the threshold would be over. But for option 2, this new threshold or row would be for the 100 million to 1 billion. Under option 2, there would be a similar phase-in approach with 1 additional year to the implementation timeline. So specifically, if you have over $1 billion, you'd have to complete your first audit by 2028, all the way through businesses with under 50 million having to complete their first audit by 2031. So both options would significantly reduce the costs incurred by businesses, particularly by smaller businesses by revenue, who will have more time to complete their first audit and be able to take advantage of learning and labor force developments over time. My colleague Lisa Kim is going to be providing the details of the economic impact of both of these options. And as Phil mentioned, beginning to be clear, there is a trade-off in phasing in implementation. While it certainly lowers the costs and compliance burdens for business, it also means that consumer security will be more at risk for a longer period of time. Okay, next slide, please. The additional modifications to the cybersecurity audit requirements include consolidating the cybersecurity audit report requirements. This is less of a substantive change and more just for ease of reading. So we've moved several provisions from 7122 into one subsection of 7123 and added a cross-reference just to make it clear what the audit report would have to include. The second is removing the requirements to involve a business's board of directors. This includes replacing the text that was generally saying the board of directors or governing body or the business's highest ranking executive. So in place of those, we would use a member of the business's executive management team that meets similar criteria or responsibility. This is intended to simplify implementation for businesses at this time. And again, the agency has the authority and the board has the discretion to revert to one or more of the board-related requirements as a mean to drive accountability and resources into more robust cybersecurity protections. The third is clarifying the certification of completion requirements. So this includes clarifying when a business must complete its certification, who must submit the certification and the requirements that they would meet, clarifying the information that the certification must include, and then finally, the last on this list is removing certain explanatory requirements, again, to simplify implementation at this time. So this specifically pertains to 7123B2. So this would remove the requirement that where an auditor deems a component of a cybersecurity program inapplicable to a business's information system, the audit report would not have to document and explain why the component is not necessary to the protection of personal information or how the safeguards that a business does have in place would provide at least equivalent security. And second is in 7123F. That's the provision that effectively says that a business does not need to duplicate cybersecurity audit efforts if it's engaged in another audit evaluation or assessment that meets the requirements. The revision here would be a business would no longer have to explain how the other audit assessment or evaluation they've completed meets the requirements in Article 9. And with that, I'll pass to Ms. Sheikh.
Thank you. Next slide, please. All right, turning to risk assessments, we made several high-level changes, which I'll be turning to now. Generally, the proposed revisions in Section 7150 reflect the board's feedback from the April meeting. This includes, for instance, changes to the definition of automated decision-making technology and the term significant decision, and revisions to the training threshold within risk assessments. In addition, staff is proposing several revisions to simplify Section 7152, or simplify this article overall based on our review of public comments. This includes moving the definition of significant decision to the definitions section in 7001. This was requested in public comments so that all definitions are in the same place. We've also moved the profiling thresholds into their own thresholds in risk assessments, which is intended to help address some of the confusion that we saw in public comments about the term extensive profiling and what it covered. Lastly, we propose revising the public profiling threshold so it focuses on sensitive locations for now. Public comments generally identified these types of locations as places where consumers' movements in public are most sensitive. And given the board's feedback at the April meeting to essentially build on regulations in future iterations, we'd recommend this as a starting point for this threshold. But I'd like to make clear here that the board does have authority to revert back to the more broad public profiling threshold that was in the April draft, or to expand or change the scope of this threshold as it prefers. Turning now to point 2 on this slide, streamlining the requirements for conducting and documenting a risk assessment. This is generally reflected in Section 7152 of the proposed regulations. In that section, proposed changes include introducing a new term, the risk assessment report, to clarify what must be documented as part of conducting a risk assessment. This report would generally include the purpose of the processing, the categories of personal information relevant to the processing, the operational elements of that activity, the safeguards that the business plans to implement, whether the business decides to initiate that activity, and lastly, the relevant individuals who contributed to or reviewed and approved the risk assessment. This report would also be submitted to the agency or the California Attorney General upon request. In addition, we've also made proposed revisions to provide additional clarity in this section where possible, such as how to identify a purpose or benefit with specificity, and making clear that the types of negative impacts and safeguards are listed as examples for businesses to consider as part of the risk assessment. Lastly, we proposed additional edits to this section to generally simplify implementation, such as simplifying some of the operational elements and safeguards identified in the risk assessment. Turning now to number 3, adding examples of how a business would supplement their assessment if they are, for instance, complying with assessment requirements in another jurisdiction. This is in Section 7156B of the proposed regulations. Generally, this is intended to provide guidance regarding how a business that can use its existing risk assessments to comply with Section 7152. This is both intended to address public comments requesting additional guidance, as well as the board's feedback to help businesses simplify their processes when they are complying with multiple jurisdictions. This example is specifically based off of the Colorado Privacy Act Data Protection Assessment Regulations, which staff also plans to make clear in the final statement of reasons that accompany the regulations as part of our rulemaking record. We'd like to emphasize here, overall, Colorado's data protection regulations and the proposed requirements in Section 7152 overlap significantly, as you can see in the example. And where there are differences, it's generally because there are some additional elements that we require, or that there are things that are implicit in the Colorado regulations that, to meet clarity requirements under the APA, we make explicit. And lastly, on this point, we just wanted to reiterate parts of our April board meeting discussion. There are certain limitations under the Administrative Procedure Act regarding how we can incorporate by reference another jurisdiction's requirements. Because of those limitations, we cannot simply say, if you comply with Colorado, you comply with Section 7152, but we can draft a hypothetical example accompanied by more information in our FSOR that provide guidance to businesses and that we believe will help businesses develop internal crosswalks between Section 7152 and the corresponding provisions in the Colorado regulations. Lastly, we also went through section 7157, which is our risk assessment submission requirements. Consistent with the approach discussed by the board at the April 4th board meeting, staff has generally proposed revisions to streamline the submission process for risk assessments. Under section 7157B, a business's annual submission to the agency must include their name and contact information, the time period covered by the submission, the number of risk assessments for that time period, the types of personal information processed, an attestation that the information submitted is true and correct, and the name and title of the person submitting the information. In addition, consistent with the approach we've taken in the cybersecurity audit regulations, these would be submitted no later than April 1st of each year, and the submission would be by a member of the business's executive management team who is responsible for risk assessment compliance, can provide accurate information, and has authority to submit that information to the agency. Lastly, risk assessment reports must be submitted to the agency or the California Attorney General upon request, and we proposed revising the time period for submission of these reports to 30 days, which is responsive to public comments asking for the additional time. Next slide, please. All right, turning now to the automated decision-making technology article, which is Article 11. First, we revised the definition of automated decision-making technology and significant decision, which is in line with the board's feedback at the April board meeting. In addition, we proposed removing the other ADMT thresholds from section 7200 that address extensive profiling and training uses of ADMT to simplify implementation at this time. This approach generally aligns with the board's feedback in April to simplify and reduce costs where possible and take an iterative approach to the scope of these regulations. Again, as with risk assessments, the board does have authority here to revert back to the April draft. And so, for instance, adding back in those extensive profiling and training uses, and that is ultimately a policy decision for the board of which thresholds to include at this time. With respect to number 2, providing flexibility and clarity regarding timing, that's in section 7200B of the proposed regulations. We've included this language for the board's consideration regarding the timing of the ADMT article. As you'll see, this provision generally provides businesses until January 1, 2027 to come into compliance with this article's requirements. Although the agency is not required to provide this time of extension, it is intended to facilitate businesses' compliance while ensuring that businesses can, that the consumers can exercise their opt-out and access rights no later than 2027. I'm now going to hand it back to Ms. Anderson.
Thank you. As you'll see in section 7220, we've also proposed modifications to streamline the pre-use notice requirements in several ways. First, we provide guidance to businesses on how they can consolidate a pre-use notice with a notice at collection, which is something that was requested by comments. Second, we've provided additional clarity about what information must be provided to consumers in the pre-use notice, which includes how the ADMT processes personal information to make a significant decision, including the categories of personal information that affect the ADMT's output, the type of output generated and how that output is used to make a significant decision, and what the alternative processes for making a significant decision is so that consumers who've opted out understand what that will be. These proposed revisions ensure that consumers will have relevant factual information prior to deciding whether to exercise their opt-out and access rights. We've also made clear that businesses must provide the information required by a pre-use notice, but that businesses are not required to disclose trade secrets or certain information related to security, fraud prevention, or safety as they do so. Fourth, we've streamlined the opt-out exceptions for human appeal and certain decisions. For the human appeal exception, we've proposed revisions to the relevant qualifications that the human reviewer must have and their role in the appeal process. Specifically, the human reviewer must know how to interpret and use the output of the ADMT that made the significant decision that's being appealed. They must have the authority to change that decision based upon their analysis. And they must actually review and analyze the output and any other relevant information to determine whether to change the significant decision at issue. That mirrors the criteria for the quality and degree of human involvement that would result in decision-making not being deemed to be ADMT for purposes of our regulations. Second, with regard to the exceptions for admission, acceptance, hiring, and allocation or assignment of work, we've also proposed ways to streamline these exceptions. Specifically, to qualify for these exceptions, businesses must use the ADMT solely as outlined in the exception and ensure that the ADMT works as intended and does not discriminate. These revisions are how we've proposed to balance providing flexibility for businesses in qualifying for the exception while being responsive to consumer groups who have raised concerns about erroneous and discriminatory uses of ADMT. Fifth, we're clarifying what must be included in response to a request to access ADMT. With respect to the right to access, we've proposed revisions to the right, and those would require that a business disclose to the consumer the purpose of the processing, information about the logic of the ADMT, and the outcome of the decision-making process for the consumer, including how the business used the output to make the significant decision. We've also proposed revisions to provide additional guidance on how to provide meaningful information to consumers for each of these requirements. I'll now pass to my colleague Lisa for.
So next slide, please. I'll be focusing on the our preliminary economic update based upon the modified regulations. The board's decisions during the April meeting had significant impact on reducing the cost of the regulations, at least in the direct year. And I just want to kind of note that, we did not have a significant amount of time to really go into depth on this economic analysis, but this is based upon our conversations with economists as well as some internal research that we've done. And this is kind of our best foot forward to give you guys, give the board enough information to understand the impact, at least initially, with regard to the changes that were made. But as you will note, based upon the modified text of the regulations provided to the board, there was a significant reduction in first-year direct costs of about 64%. Note that that is taking into consideration option 1 with regard to the phase-in of the cybersecurity audits, so breaking it down into 3 years rather than 4. I'll just touch upon briefly what kind of contributes to these cost reductions, starting first with ADMT. The reason why the ADMT cost of the regulations went down significantly was because of the changes made to what is brought into scope of the ADMT regulations. So as you know, there was significant changes to the definition of ADMT, as well as limiting the regulation scope to just those in which there was a significant decision made about the consumer. And because of that, our estimation is that at most, and again, preliminarily, at most, we think only about 10% of the firms would be scoped into that to be required to comply with the regulations based upon the activities that they're engaging in. That's different than what the previous assessment.
I'm sorry, 10% of what firms?
Of the total firms that are subject to the CCPA. So to take
10% of the firms would be the only ones subject to the ADMT regulations?
That is our estimation.
Thank you.
Yes. So previously, we did a scenario analysis where we were looking at both 25%, 50%, and 100% of the scope of businesses that would have been subject to the ADMT regulations. And in our estimation, that made sense previously because scoped into that was behavioral advertising. Because that was removed, that led to a significant reduction, which we think is 10%. And so that accounts for the 83% cost saving or cost reduction, excuse me. With regard to the cybersecurity audits, there are 3 things I can think of. 3 things I want to articulate is the result of the cost reduction. First is that we reevaluated our assumptions. One assumption with regard to whether or not firms subject to these regulations were already using security frameworks in place. Initially, the economists conservatively believed that it was only a range between 10 to 50%, depending on the size of the firm. But looking back at our assessment of what the CCPA already requires since 2018, we believe that all firms should be already using a security framework. And this is based upon our analysis of Civil Code Section 1798.100, which requires that everyone have reasonable data security procedures and processes in place, as well as the AG report and previous guidance given by the Attorney General that this should be equivalent to, at least equivalent to CIS's CSC controls. And so we think that that prior assumption we made should be adjusted so that all firms subject to these regulations should have that 30% consideration that they are already using pre-existing security framework. Now, the second thing that has changed is basically a simplification reflected in the modifications of the regulation text as to lessening some of the requirements required under the cybersecurity audit, primarily as my colleague, Ms. Anderson, spoke to. There's less explanation required, less explanation as to why certain components are not applicable. And we, excuse me, we believe that we estimate that would reduce the number of hours it takes to prepare a cybersecurity audit by 25%. So that is also a contributing factor. And then finally, the third contributing factor, at least with regard to these numbers, is this phase in of the cybersecurity audit requirements. With regard to how that is phased in, there are significant impact to giving time to adjust in the economy with regard to allowing for changes in the workplace, allowing for time in which businesses have more time to procure an auditor, to be able to implement those changes or to implement the requirements associated with the cybersecurity audit. And so that change in phasing in of approach would lead to significant reduction in direct costs and present that over a time period. And I believe we've provided in our memo to you the kind of breakdown of that over a 10-year time period. And then finally, with the update regs, there were some recommendations as to things that we believe should be, that staff recommends taking out to kind of simplify implementation at that time. And there were some cost reductions in that, to that effect. So I opened it up to questions by the board.
Thank you very much for the really helpful overview from Ms. Anderson, Ms. Sheikh, and Ms. Kim. I want to invite Dr. Nanaki to speak first if she would like, because she didn't benefit from the discussion last time, but I also don't want to put her on the spot. So let me know, Dr. Nanaki, what you would prefer.
I'll happily be put on the spot. I
Yeah.
have some follow-up questions. One is a clarifying question. Given SB 468 for high-risk AI systems and you seeking that it be amended to grant CPPA authority, aren't these in conflict with each other? I mean, if we do our regulation, then we would already be doing that.
Happy to try to take that one. So a few just initial observations is I think the scope is a little bit different in terms of what SB 468 addresses and what these regulations do. These are cybersecurity audit requirements for all firms based on their processing activity and revenues, essentially, as opposed to, I think, the focus of SB 468 being a little bit more specifically on, I think, deployer development of certain types of systems, right? So the scope here is broader. We also have a statutory mandate to do this requirement, cybersecurity audits for high-risk processing. And at the same time, I'll just note what was discussed earlier. That bill currently includes rulemaking authority for the agency for that law if it passes. And so certainly I think if it needs to be further alignment, we would absolutely engage in that. But for now, I don't think we've necessarily seen that as a direct conflict with what's being proposed today.
Yeah, I'm just curious. I wonder if firms, though, might get confused. What do I need to comply with and what do I need to do? And that gets to my next question around risk assessments. The field is evolving right now of what does an adequate risk assessment look like for these types of systems. I had mentioned earlier McNerney's bill, SB 813, which does propose to develop this multi-stakeholder panel that would help define what do these actually look like in practice. but I also want to flag Assemblymember Rebecca Bauer-Kayen's bill, AB 1405, which would establish qualifications for audit and risk assessments, and auditors would be able to be essentially like licensed with the state, which really provides more clarity. I am sympathetic to businesses being compelled to do risk assessments under the uncertainty that that third party is actually doing due diligence. And so I think more clarity around what does a risk assessment actually look like? And then the third part of that, are these risk assessment reports going to be publicly disclosed?
Great question. In the proposal for now, it would not require public disclosure by a business of these risk assessments, and even the agency would only receive the full risk assessment if it was requested specifically by the agency or the Attorney General's office.
Okay, and a follow-up for that is, how can you use those reports to help inform what does an adequate risk assessment look like? How can you, identify industry best practice? I believe that the European Union is doing that via the EU AI Act, and they must report these risk assessments and conformity assessments, and they're using those to better understand what does this environment look like and how does it align with our standards that are being developed. In Europe, it's CENELEC. Mostly for us, it's NIST, IEEE, ISO.
So on that, I see it as really a twofold approach. So first, there's the annual submission requirement. Now, that does not require submission of risk assessment reports. That instead requires disclosure to the agency of high-level metrics, including, importantly, what thresholds actually triggered a risk assessment. So that, I think, will be an important data point for the agency to understand which of these significantly risky activities are actually essentially triggering the most risk assessments, which will help us understand, is there one threshold that doesn't seem to be triggering it? Is there something we need to amend or consider further there? And so that's the first data point. And then with respect to the risk assessment reports, we are trying to be as clear as possible, meeting APA clarity requirements about what needs to be in the risk assessment, how a risk assessment needs to be conducted, and then what must be specifically provided for in the report. And so I think once we receive those reports upon request only, I think that is where, to the extent that there is any further clarity we can provide, we can always amend the regulations accordingly. And I think that goes to your initial question as well, which is, to the extent that there are other legislative developments that are happening that we want to take into account, it is something that we can always revise the regulations to further harmonize across essentially the California code as we need to. I mean, of course, within our authority. And on that point, one thing I would like to make clear is with respect to what's currently in Section 7152, we have done our best to really harmonize it as much as possible with Colorado's regulations, as well as the what we've seen as guidance provided by data protection authorities in Europe. So for instance, the UKICO's DPIA template we did use and thinking through, what really are the most necessary elements for a business to conduct a risk assessment at this time. And again, to the extent that we see further developments in this area or further guidance from the legislature, and of course, the board is always welcome to provide us with additional feedback, we can amend the regulations as necessary to really account for those types of changes.
Great, thank you. And I just have one follow-up for this. At the federal level, Senator Hickenlooper, a Democrat from Colorado, is reintroducing the VET AI Act, which would charge NIST with developing standards and guidance on what a third-party risk or impact assessment looks like. So that could provide greater clarity. My one concern is that if we're just calling on industry to identify what does a risk assessment look like in practice, we could reach a position where they're essentially writing the exam by which they're graded.
Thank you. And that is actually something, we did receive during the preliminary rulemaking that we did on this topic, concerns about just this being a paperwork exercise, right? It's simply just filling out a checklist. And so what we've done throughout the regulations is really try to provide accountability where possible. So I think one of the most important provisions is the attestation that a member of the executive management team will provide to the agency that the information they're providing is true and correct in their annual submissions about the amount of risk assessments conducted. So that's one important accountability mechanism. Then there is the actual conducting of the risk assessment. One of the things that has to be in the report that is provided to the agency is the safeguards that the business plans to implement. And so I think that is going to be just an important accountability mechanism overall. But I think in terms of actually making the risk assessment meaningful as an exercise, a business conducting it as we outline in Section 7152, and then hopefully as part of that assessment, identifying the relevant safeguards that are necessary to mitigate the risks that they've identified. You know, that is part of the accountability framework. And I think what you're really asking is like a broader question, which is really, how do we make sure that these risk assessments are meaningful and are being conducted appropriately? I think we're all going into this assuming really that businesses are acting in good faith, and I think that is a very fair assumption. But when it comes to these risk assessment reports, our enforcement division will be able to ask for them. And to the extent that they are, just as part of any other investigation, seeing non-compliance with the regulations, they can of course bring an enforcement action, and we can learn from them, from these enforcement actions, in terms of what changes need to be made to the regulations as necessary to further bolster accountability. And so we see this as really an important first step in these regulations to build accountability, both in the report itself as well as how a risk assessment is conducted. But then through our own learning, we can of course enforce non-compliance as necessary. That's the enforcement division side of the house. But then amend these regulations as needed to ensure that this is not simply a paperwork exercise by businesses.
One final clarifying question to make sure I understand that the risk assessments, those can all be done internally. There's no requirement for a third party.
There is no requirement, though we do allow, it was never prohibited, but one thing we do make clear in Section 7151, actually, sorry, let me address that in 2 points. Section 7151A does say that the people who have the relevant job duties for that processing activity should be part of that risk assessment. So to the extent it might actually involve, you know, selling or sharing personal information, and there might be other parties involved, you might need to get information from those parties. So Section 7151B makes clear the people who are part of that risk assessment should be part of conducting it. And then Section 71B does provide guidance that a business is allowed to include external stakeholders as part of the risk assessment process. We have not made that an explicit requirement. Again, just to be mindful of where businesses potentially are now. It is something we can think through in the future of whether or not something that needs to be bolstered further. But at this point, especially given the general direction from the board of building slowly and simplifying implementation now, we'd prefer to have Section 71B as guidance.
Thank you.
Thank you, Dr. Nonike. Mr. Worth?
I had a few things. No logical order, which is kind of how my brain works. I thought there was a comment made earlier, if you're performing another type of audit, that could qualify for the requirements here. But then I thought you said something along the lines was interesting about we had no right to. I was trying to figure out how you connected it. It was almost like you could say, yeah, I did it somewhere else, so I don't have an obligation here. That's kind of what I heard.
So I think you're talking about 7123F in the cybersecurity audit.
Thankfully, I don't have them memorized like you two do, but I'm sure that's where it is.
Right. So that the concept there, the thing that we got rid of is that a business would no longer have to explain how what they did actually meets all the requirements. They do still have the requirement that in order not to have to duplicate work,
right,
what they've already done has to meet all the requirements that are articulated in Article 9. What we took out is the need to specifically explain how what you've already done meets each of the provisions within Article 9.
But they have to attest that it does.
They do have to certify that
Okay,
they completed
perfect.
the cybersecurity audit requirements.
Okay. Jumping around, thinking about this 15-day period potentially where we may be headed, when was this information made public?
This was posted yesterday on our website.
Okay, so that would be April 30. And when would the 15-day period start?
We could start it as soon as next week.
Meaning, like, just give me a date. May.
Let's see. Let's call it 6th.
Okay. So we inherently have 7 days built into the 15, so it really would be at 22 days from when this information was made public. Is that accurate?
Absolutely, to your
Okay.
point. If it's this version of the text that's been published, then
Yeah, to the extent it's this version, 15 becoming 22 to me sounds like a ample amount of time. It's over 3 weeks. Moving back to the timelines, I think there was option 1, option 2 on the audits. I believe there's this January 1st of 2027 option for the ADMT regs, correct? I'd love to have a discussion amongst the board, but one of the things that I think with the short period I've been on here, we've struggled with is getting things accomplished. And so the concept of me of like, the larger companies have 3 years to get there. The smaller ones have 4 and 5 years, but we want to add another year to that. 4 years is a long time from now. It's an Olympics, basically, right? I mean, so I just don't know why we need to, yeah, we hope, right? Why we need to add more time when I think that's ample time for, a business with over $1 billion in revenue is pretty sophisticated. 3 years is a very long time to get up to speed on what you need to do, in my opinion. So I'd like to have that conversation here, because I think that probably came from some of our, and it could have even been some of my comments. But now, part of why we do this is to reflect on where we are. And the final point I'll make is, I heard Chair's voice change on the 10%, which I appreciate. I would say I'm actually comfortable with where we are, because I think the purpose was, let's get this started. Let's not overwhelm both the California community and our own agency. We can always make changes over time to these regs if we think we need to include more people. But as much as the 10% sounded like a very low number, I think and I really appreciate all the effort that was made, both to the savings numbers and the number of businesses that would be captured, because that was a point we asked for, and you had a very short time to figure it all out. But I'm good with that, because I know we can always adjust in the future. I'd rather start at a lower place than a higher one. That's all.
Thank you.
I think we have just
It was surprise. It didn't necessarily have a valence of positive or negative. And I'm looking forward to it was surprise, yes, board conversation. There was a response to Mr. Worth's questions. Wonderful, thank you.
Yes, with respect to the phase-in, those are just options that we're presenting to the board. Again, ultimately, it's a policy decision for a consensus of the board to determine. Just to refresh folks' recollection, the original version of the draft would have had submission in 2028, and so that would have been about 3 years from now, about 2 years probably from when the regulations would go in effect. And so just in case that you want to have that as another option for discussion, the original version, I believe, was 2028 for submission.
for all
everybody,
companies,
for all.
businesses.
Yeah, I'm comfortable with option 1 personally, but we're not here to, I don't think, discuss that yet.
Thank you, Mr. Worth. Mr. McTaggart?
Chair, how would you like to do this? I have comments on all 3, the cybersecurity, risk assessment, and ADMTs. How would you like to do it one at a time, or how would you like to do it?
Everybody else has gone one at a time. Everybody else has gone through their questions on each item. So I think shoot.
All right, then. So first of all, I think these are in much better shape than they were. So thank you for that. It's been a tremendous amount of work in a very short amount of time. So I want to acknowledge that. So talk about risk assessments article. Well, actually, no, two separate things here. Cybersecurity, I'm not super focused on this one. I think the only thing, and this is more subjective, it's really in E of, what is that? Probably. You know, we have 5.5 pages, yes, of requirements. And a lot of them, you look at them, they kind of are sort of check the box. Do you have, 2FA? Do you have, strong passwords and all the rest of it? So I think that it's longer in writing than it would be. Whenever I get into like E, 1, 2, and 3, those are the ones that kind of stuck out at me as sort of a little bit subjective, why the processes were appropriate for the audit. I think that's...
Can you provide page numbers?
Yeah, that's on page 81. And so E1 and E3 sort of, this kind of got a little, it felt a little bit more subjective. But this isn't something I feel strongly about. Just maybe in the time when you go back to look at it, you could take a look at it and say, so, because I don't know, I actually know if you were going to look at a straight sort of gap audit of a company, does whatever the National Accounting Board have the same kind of subjective languages? So that's all. I don't really need to spend a lot of time on that one, but it was just those three, E1, 2, and 3 seemed, or really 1 and 3. And unlike Mr. Worth, I think I would support a phase in. One of the things I'm a little concerned about is just the availability of auditors. Like, we're going to be creating kind of a new industry here of auditors, and there's going to be a scramble for them. And I'm trying to think, okay, it sounds, okay, Olympics sounds like a long time, and then every time you think about the Olympics, they're never ready on time, and they can't get the stadium finished, and they're finishing it off as the guys are walking in for the first opening ceremony. So I think that's a little bit of I think it's easy to say, but I'd also be interested, do we have a cost impact if we delay it out that fourth, go to option 2 versus option 1 for year 1?
Yes, we do.
You could just give me the option 1 versus option 2.
Well, so the cost is kind of broken out per 10 year.
Mm-hmm.
It would be focused on, like, if you look, they're all, I guess the best I can do at this point is refer you back to the 10-year chart that was provided with regard to the breakdown of original costs, option 1 costs, and option 2 costs, and how it spreads it out over the 10-year period.
Where's that?
It's in the memo.
Okay.
Is the meaningful savings, though, if you take the same 10-year period and I start something in 2028 and I start something in 2029, you're going to have one less year in that window. Is that the meaningful difference between option 1 and option 2? Or is the advance of time making things easier on people as well? That was the part I was trying to dissect.
Yeah, so we weren't able to provide any kind of macroeconomic.
Because we gave you like 2 days to do it? Is that
Yeah,
what?
essentially. But there's certainly going to be adjustments with regard to, if you delay the time, there's going to be more time for workforce to come into effect and changes within the economy and building of things. There's definitely going to be an adjustment made. Whether or not that option 1 and 2 is that significantly different than the old costs, I can't speak to at this point. But I can also just point to the fact that if you were to add up all the costs over 10 years for each one, I'm going to have to go back and look and see how much of a significant difference there is between option 1 and 2 if you were to look at a 10-year summary of just the direct costs, not including any kind of macroeconomics. And certainly, if there's a break, I can speak with our economists on staff to see if there's any additional information we can provide to you today.
I have a process question about this. I have my own comments about the implementation delays, but specifically and substantively. But with regard to the auditor availability issue and the ease of implementation that the different timelines actually buy, which is a good point by Mr. McTaggart, we're talking years no matter what. And I guess my question then is, what would be the process, or is there a process if we get to year 2 or 3 and there seems to be evidence that either there are lots of auditors or that the sort of audit capability is proving hard to build, that we could adjust at that time if that were the case? The latter is probably the thing that, because I wouldn't want to change expectations that we built.
Yeah, absolutely. Obviously, we can amend these. These are regulations we're creating, and we can amend these regulations at any point based on what we're observing in the marketplace and concerns being raised.
Okay, thank you.
To that end, could you do more research in the next period, just talking to economists, to the whole idea of, like, does this get cheaper as it goes along? As the audit capability increases. I mean, do we have to decide today on the option 1 versus option 2? Could we have the flexibility to decide it at a later meeting, or is this now set in stone whatever we decide?
What I can say is, if we were to start with one option now, We would have another public comment period. When we return to the board, you'd have sort of feedback on that position. We'd also be prepared with additional sort of the final economic assessment of these costs and benefits. But at that point, if you were to change again then from option 1 to option 2, for instance, that would actually necessitate then another public comment round. And even if it was just the only thing you changed in the regulations, we would have to do another public comment round. And we could, absolutely. We still have until November to complete this, but
Okay, so I have
Mr. McTaggart?
Yeah.
I did some quick math. I ignored year one, the difference between option 1 and option 2 cost-wise. I ignored year 1 only because one of them's not starting. I don't understand, and maybe this is something we could just look at today, why year 4 has a $180 million difference. All the other years have between 18 to 34 million. So they're kind of, right? But if you could figure out why year 4 is such an outlier, I think the point's going to be that they're basically pretty much the same. It's more expensive for your option 1 in the later years, and it's more costly for option 2 in the earlier years.
I think the difference is the number of firms that come into play, have to come into compliance versus 3 and 4. But certainly, I'm going to come, well, if we could take a quick break and just make sure that I can speak intelligently about this, I would love that. On a high level note too, is that there is, after you've done one cybersecurity audit, the next year there's significant cost reduction in preparing it again. And so that is also a distinguishing factor. And I also wanted to raise a point that was made by Mr. Liebert last board meeting as to whether or not annual is something that the board wants to revisit on a legislative level to see if, you want to go back to the legislature and think about whether or not an annual cybersecurity audit is really in the furtherance of people's privacy and taking into consideration, resources and that sort of thing.
Thank you. I'd actually like to hold that so we can continue the discussion, but we will certainly give you time, Ms. Kim.
Okay, so one other question, Mr. Lair, which I wasn't too sure of. So the 15 days plus the 7, as Mr. Wirth said, okay, it sounds like a lot, but actually this is a lot of work. If we extend that to 30 days, 2 questions. One, can we do that within the timeline? And then the second question is, what I wasn't too sure of, we keep on hearing about this deadline, but as I understand the deadline in November, if OLA doesn't like it, they kind of send us back a stuff saying, fix this, and we have another 120 days to fix it. We don't have to start all over again, right? We could just fix what they said. So the 2 questions is, can we do 30 days? And then the second question is, if it's terrible and we hit the thing and they say, nope, we're not going to approve, you still get 4 months to fix stuff, right? So what's the big deal about November?
Great questions. So for the first one, you're absolutely right. 15 days is a minimum. It's not the maximum. At the same time, as you know, to begin this process, we started with an almost 90-day public comment period. And so again, thinking about our timeline of 365 days to get this done and knowing the board is scheduled to meet again likely in July, for staff to be able to receive comments and process them in time for that board meeting, I would recommend not going beyond 30 days for a public comment period, but certainly 15 days what's statutorily required. In response to your second question, you are correct. But I think the whole point we've been trying to make is that that still requires this board to adopt regulations, to agree on regulations to submit to the Office of Administrative Law. And so that adoption and that submission needs to happen by November. And if that didn't occur, then we would start the process over.
Okay, so personally, I kind of think I'd rather get it right, and at the risk of going into that 120-day period, I'd rather give stakeholders a chance to really fully kind of digest these. And so that's cybersecurity. Now I want to turn to risk assessment and to ADMT. So one of the questions, I think that regulations can further define what's in the statute. And if you look in the statute, the definition of profiling is not, I think, adequate for what we're doing here. So in 7150, this is now page 85, and this is B4 and B5. And my questions about B4 and 5 are, we got to do a risk assessment when we're profiling a consumer through systematic observation, when they're acting, But if you go back to the definition of profiling, because it's got this kind of loosey-goosey, undetermined term of automated processing of information, I think that's a problem. Because now what you're really saying is if you use any kind of automated, and which is undefined, what does that mean? If you're using automated processes with respect to a applicant, a student, or a employee, so to me, that means your basic HR, did you get paid? Okay, now you have to do risk assessment. Did your card key work to get you in the building? Because that, and especially it's profiling a consumer based upon their presence in a so sensitive location. So if I'm an Uber or a Lyft and I'm getting you a car to a hospital, I've now, under this one, I've profiled you. And I think that, again, what we should be trying to do is what are you doing with the information? And so either I would really kind of re-look at 4 and 5, because I think that we're casting way too big a net, and we're saying do a risk assessment for stuff that right now is very, mundane kind of use of technology that we've been using it for 40 or 50 years. So I think if you change profiling to instead of any form of automated processing, it could be ADM, but still the problem with if you put ADM in there is for the, DoorDash delivering pizza to the nurses at the hospital, suddenly it's, a risk assessment. And that, that doesn't make any sense. If you're delivering the pizza to the nurse at home, no risk assessment. But if you're delivering it to the nurse at the hospital, then a risk assessment. So I think that there's an issue there. And I'm happy to, we don't really need to debate it. I could be wrong. Do you feel like I am? Or?
So yes, with respect to the definition of profiling, I think one thing to keep in mind, I'm not sure if the DoorDash example would be scoped in, because it's not simply that it's an automated process to get someone to somewhere. I had always understood profiling based off of the statutory text to be, it's an automated process to evaluate that person and specifically analyze these specific characteristics about them.
It's their movements too, so it's where they are.
But again, it's evaluating the consumer based on their movement. So it's developing some sort of evaluation about them, developing a profile about them. But if the general consensus from the board is, it's not like we understand that there are risks to essentially tracking consumers' movements at these locations or tracking them within these locations, or within number 4, tracking employees through systematic observation. If the board is generally aligned on wanting to have those trigger risk assessments, but essentially tighten up the language a bit, that's something we can do and think through. And again, we could potentially use a break to think through potential options here.
I think this is like the whole definition of whatever pornography, when you see it. If we're talking about tracking someone to the reproductive health clinic to make sure, oh, you're going to see her, we're going to now track her back to Utah, clearly terrible, right? And so, but delivering the pizza to the reproductive health clinic, not a big deal. And so I'm trying to distinguish, and I would just urge you to kind of wear that hat when you're going back and maybe take a look at these, because I think that you could tighten these 2, 4, and 5 up to kind of exclude a lot of the, what I'll call is just the nonsense, really stuff that shouldn't really, I don't think in anybody's mind, trigger a risk assessment. If you go to San Francisco General in the Uber, is that really, now if they're doing it and they're like, oh, this person has this disease and we're going to create this long, because it's the 4th time he's been there in this long, that probably is dialysis, and then we're going to say, okay, this is our dialysis patient. Clearly that is. I think that the language is too broad right here.
And I might just jump in to say, I think what you're describing though is the assessment essentially of, at least from your stance, what is risky and what's not. And that really is for this board to decide. I just want to say, I think we're happy to support what the direction is, but I think you all need to tell us what, I'm hearing one position on the risk, but I would need everybody to kind of give us direction on which risk should be scoped in and which shouldn't.
Yeah, we should have a broader board discussion about that policy point. I do not read this language the way you do, Mr. McTaggart, because I also read it as filtered through the statutory text, which it must be. But I have no problem with a technical amendment that reflected the board's consensus, but we don't yet know what the board's consensus is.
Yeah, and I don't actually think it'll, I don't want to speak for the board, but I hope it wouldn't be contentious. I I mean, I think we're all saying, look, if you're evaluating creating a profile and you're saving that profile and you're really trying to infer things about a person based on, and you're creating this big longitudinal profile based upon the fact that, you get pizza at the hospital, that's one thing. But I think there's a lot of kind of pretty simple technological, the way the world works is going to get caught up just, again, if I go back to my card key just to get into my office building, that is a systematic observation of me as an employee using automated processing of PI. And I think that's not, just because you have a card key system in your office building doesn't mean that.
I think we take the point about your concept of the risk, so maybe we could move on and take this up as a board.
Okay. All right. Then I have on page 90, this is now 7152. I think what we were trying to do was make this facts. At one level, this is kind of moot because the preamble negative impacts to conceive these things, A through G on that page, A through H, I guess on the next page, are really very subjective. And I like, for example, B, and the reason I want to minimize things here is because the statutory language says the risk to consumers' privacy or security. So then I look at B, this is not a risk to your privacy and security. It's illegal, you can't discriminate, but I don't know why it's in a privacy statute. I look at D, the pricing thing. Again, it's not a privacy or security issue. And so I think that obviously F that's privacy and security. But I think much of this is, I don't know, fodder for opposition to say, look what they're making us do. And I don't think we need it in there because, first of all, it's May, so that people probably will ignore it. And I just would take it out because, again, I don't feel like it's supported in statutory language of privacy or security.
May we respond?
Sure, yeah.
So in terms of the negative impacts that are listed here, as a may consider, they are in there to provide some clarity and guidance for businesses. As we discussed before, the discrimination as a privacy harm is something that the text of the CCPA, as well as other privacy frameworks, including Colorado, academic scholarship, and government entities, all support as being a privacy harm. The use of, or this entire list, all involve the use and processing of personal information that results in negative impacts to consumers. So the nexus is in the use of personal information. So with respect to discrimination, CCPA's definition of sensitive personal information includes things like racial or ethnic origin, citizenship or immigration status, religious or philosophical beliefs, genetic data, and personal information about consumers' health or sex life or sexual orientation. Those recognize that discrimination on those bases is a privacy harm. In terms of other privacy frameworks, Colorado's data protection assessment regulations require businesses to consider the source and nature of risks to consumers, and they include in their list of risks that controllers may consider, very similar to what we're doing, discrimination harms, such as a violation of federal anti-discrimination laws or anti-discrimination laws of any state or political subdivision thereof. Privacy scholars, government entities, including the NIST Cybersecurity Framework and the NIST Privacy Risk Assessment Methodology, also all recognize discrimination as a privacy harm. So we do feel that is something that should be retained, but I think just on a broader level, these lists of harms are privacy harms because they're the use of personal information that result in negative impacts to consumers that businesses should be considering as part of a risk assessment.
Not only that, but 1798.125 of our statute prohibits retaliation against consumers, largely for financial situations, but also in employment. And the language that it uses is that a business shall not discriminate.
Yeah, I think my point is that in the enabling 185A15 here is a risk to consumers' privacy and security. 125 stands on its own. and is related to the sale of data. Anyway, I don't think this is, I just wanted, I'm interested in making this area tie into the preamble in 185A15 as much as possible. But again, since it's May, I don't think it's super important. And, you know, the difference in Colorado is they had a law that specified this. And I think we're basing this on the 185A15. So I don't necessarily, you know, for example, H, we're getting back into the, you know, into the subjective thing of what's the psychological harm for, and the business has to figure out what the psychological harm is. Now they don't have to because it's May. So again, I just think this gets right back into the whole ADC thing. But anyway, so that's the one I feel more strongly about for risk assessments is the profiling. And then on
I'm sorry, Mr. McTaggart, just because I've been turning around the profiling point in my mind, and I just want to be sure. You're concerned about the drafting? And then we need to have a sort of, you know, the board either can give guidance or just say we want to get comments on the overall risk profile that we're talking about here as far as a privacy risk. But is it the word profiling?
Well, it's either the word profiling or the definition of profiling, but the fact that you
The
have
definition in the reg, sorry, I'm just trying to be
the
straight.
fact that because what I'm suggesting is that the definition of profiling in the statute needs to be further clarified here if you're going to use it in this context, because the definition of profiling in the statute only refers to automated processing of personal information, which is not a defined term. To the extent that you use software, essentially, to evaluate, what does evaluate mean? Personal aspects relating to a natural person and their location, their movement, their performance at work. That's really that's HR, that's basic HR stuff. That's like, did I show up at work today? Did I card key in? Did I come in through the parking lot? You know, did I, and I think that's not what we want to trigger risk assessment. Because at least personally, I feel like we want to trigger a risk assessment when the behavior is risky, but I don't feel like, you know, the Excel spreadsheet kind of keeping track of people's hours is something that's automated processing, but I don't think that should be risky. That's my take. Now, maybe we all have a different point of view, but at least for me, I don't feel like that should trigger us, put us over the edge. And I think the drafting could be tightened up and it could be done in a way that would not harm what we're all trying to do here. But I do think that because 4 and 5 on page 85 refer to profiling, and profiling refers to automated processing of personal information, which is not defined, and it talks about movements and location. I think you're opening the door to a much broader risk assessment that does not do anything to help risk per se.
On this point, again, I would appreciate any guidance from other members of the board in terms of what use cases should and should not be scoped in. This is where I actually would say a 15-day comment period would be particularly beneficial. I'm assuming that practitioners, there's about 277 people watching this right now, are paying close attention to what our board members are asking for additional feedback on. And this is one where, given that it goes to how are businesses using these technologies and how are consumers most harmed by them, this is where I'd really request a 15-day comment period so that we can get commenters who are actually using these technologies and experiencing them on the ground to give us a bit more information. I would say these thresholds generally got less attention in the 45-day comment period. I think people were focused more on the use of ADMT for significant decisions. So I would really appreciate specific use cases that folks are more concerned about so that we can tighten up. Like, we obviously, to the extent the board has suggestions today, we are absolutely happy to implement them. But this is where I think benefiting from feedback from individuals and businesses would be particularly helpful for us to make sure we're scoping this appropriately.
And do you think 15 is better than 30?
Oh, sorry. I say 15 because that's the statutory requirement.
Yeah.
Again, whatever the board
Oh,
ultimately
okay.
decides. Apologies that I just
Yeah.
used the statute
Sorry.
timeline.
Sure, yeah, I think there's what I don't want to have, I guess my view of the world is not to take everyday, normal, non-risky kind of software processes that we all have become accustomed to even before the internet, frankly, to all of a sudden trigger a risk assessment. And I think a lot of HR normal stuff like getting your paycheck will be triggered here. And so that's my risk assessment comment. And then in my comments on ADM, so I have one comment on page 103. Well, actually, no, I'll leave that one alone. Let's go to page 107 and 108. And this is 7221, B2 and 3. This is, you just kind of talk about the opt-out. I think we're missing in both cases an if. So it's, you know, if I read 2, it's for admission, acceptance, or hiring decisions set forth if the business does the following, right? And in both cases, I want to talk about the word ensures. So that the A is pretty clear in both cases, 2A and 3A. But the B is ensures that the ADM works as intended and doesn't unlawfully discriminate. So first of all, you know, if you're a small business, again, how are you going to ensure? If you're a big business, how are you going to ensure? We're a privacy statute, and now we're going to say to the gig company, hey, you got to ensure that your algorithm, which assigns work to the pizza deliverer or to the car, is not unlawfully discriminating based on protected characteristics. So you're going to say to like an Uber or a Lyft, we're going to have to keep track of everybody's race, everybody's gender, every sexual orientation. Somehow I'm going to have to make sure that I'm allocating cars, you know, not in a discriminatory fashion. And we're a privacy agency. We're going to make these companies collect all this information about people, about their workers, that they may not, you know, it kind of feels backwards for a privacy agency to say, hey, by the way, I want you to become like a civil rights agency. And obviously it's important that this doesn't happen, but there's a ton of civil rights laws out there. And so I don't know how if I were a business, would ensure. Now you could maybe make a reasonable effort, but I would urge us to change that word, change that verb to sort of makes reasonable efforts, because you know, if I'm that business, I may not want to collect all my gig economy races. Yeah.
Just a question on the example. Let's just use the Uber or Lyft example. If my technology sends the closest car to the consumer, I'm not discriminating. So I don't need to worry about all those other things. If I'm choosing to not send somebody because of their race, then I am.
Sure, but you would have to know their race. I just want to.
But I don't. If I just send the closest car, I don't have to know anything.
Yeah, I just want to make sure that.
Unless I say, hey.
How do I well, I think that the word ensure is almost impossible for the business to.
There's almost back again. This is not the same place you had it, but almost if you are, then you. I mean, somehow you need to put the onus on if you're actually in the act of discriminating. Then somehow I want to. You know, I mean, I think it tightens it a little bit.
Yes, and also remember that only a subset of businesses are doing these risk assessments, and they're already doing them for a subset of reasons underneath the chapeau language. But I think, again, we have a focus on the word ensure, and then we also have a lot of perception about what is risk that is relevant for our remit. With regards to the word ensures, I believe that, and staff can tell me if I'm wrong, is that this was revised in order to reduce the burden on the business and to give the business more flexibility in how they chose to use the risk assessment process to understand their practices, and that the ADMT technology is both working as intended and that it's not discriminating. So based on what was there before, which had a much more sort of specific, prescriptive set of things the business had to do, my understanding was that this was intended to give businesses some flexibility within the APA's limitations on that flexibility because of the fact of the clarity standard in California. We are quite limited in our ability to provide flexibility in that way. Is that a correct assumption about this?
Yes.
Okay.
So this is more of a performance-based standard. So
Yes.
we're not prescribing how they insure. We are just putting in that performance standard that they insure.
And-
Yeah, so a performance standard, right? Yeah.
And I'll just note, of course, this is an exception, so a
Mhm.
business is not compelled to do this. They're only required to do it if they want to avail themselves of this particular exception.
Okay. Thank you.
Sorry, just the last thing that I want to say on this. So with the idea of the performance standard, this is also one, again, taking the long view of these regulations. Part of the reason that we up-leveled this is so that businesses have the flexibility at this time. We can learn of course, through the public comment period, but also once they go into effect, how businesses are actually taking steps to ensure, identify what best practices are, and then revise the regulations to provide guidance. So the idea here is we're creating the flexible standard now for businesses with the goal of learning from what these best practices are and ideally providing a bit more guidance in the future. And so that's the general long-term goal.
Thank you.
And then one final point. It's just that businesses already have an independent obligation to comply with anti-discrimination laws at the federal and state level. So this is just, reifying that's something that they need to keep in mind as they're engaging in these types of practices.
Yeah, but I guess this is where I get twisted up is like, I'm a small business, pick up software off the shelf, and somehow I don't know if I'm using chat, what if it's discriminating? And so I have this new obligation, and I think we should.
You don't get to discriminate, even if you're a small business. You just don't.
Of course you don't, but again, I think that the insure part is that you're saying that the ADM that I've gotten off the shelf, I have to somehow now go verify that Microsoft ADM is working as intended, which I don't think is practical. So that's why I would say you have to make some reasonable efforts to insure, as opposed to this hard standard. So, and of course, I'm not suggesting that you get to discriminate.
Were those your comments? Wonderful. Thank you very much. Mr. Liebert? Go ahead.
I think you should go ahead.
Are you waiting to hear what I say?
Yeah.
So that you can undermine them, or so that you can support them? Because when I make my decision, I need to know. No. All right. Sure. Yeah, I'll go ahead. First, I really probably should have written out a statement, which I don't normally do, as people are probably very unfortunately aware in listening to me do this kind of thing and continue my sentence. But I did not write out a statement, which I regret, because it's just difficult to express appropriately my thanks for the rigor and the care and the thoroughness with which the team has taken a board discussion from less than a month ago, and that significantly revised these regulations, significantly pulled them back, and managed to implement this in this time frame for us and for the public. It is just a real testament to, again, that skill and dedication. And for those folks who aren't privacy policymakers and aren't privacy attorneys and aren't chief privacy officers or their staff in companies, let the rest of us just all stand up and say how impressive and indeed surprising it is that you were able to do this and that you did this for California and for the agency. So thank you very much. That said, no. I think the staff, broadly speaking and overall, and in many specifics, have just made very good, careful choices that are in line with the board's expectations. They do pull the regulations back from consumer protection and in favor of businesses. Further, than the board's guidance in early April. So for example, significant decision, we had a long conversation. I remember Mr. Worth had a lot of really helpful sort of concrete questions and examples about the definition that resulted in a knowledge standard that staff were working with. We didn't cut it back. We didn't cut those thresholds back completely the way they've been cut out. And I say this not because I'm not going to support moving it to 15-day. I say this because we've really cut to the bone in terms of what is in line with the statute's requirements for the regulations we need to do, and in terms of the relative value to businesses and the relative value to the people, to the residents of California whose personal information is at stake. And I don't say that as a political sort of, I just think that this is, it's a very streamlined, fast 70-mile, actually that's not fast anymore, is it? I don't know, 120 mile an hour, is that fast? Kind of draft. And I appreciate that, but I think that it's important that I also express some concerns about the policy direction on a couple of points, because I do have some questions for both the civil society groups, definitely for individual consumers, and for businesses in terms of the easing of implementation here. A fair number of them relate to the cybersecurity audits and the using the different periods of implementation in order to find those cost savings. And I know there have been a lot of questions from the board about that. I think they're appropriate. These are very large savings compared to the SRIA, and that is all to the good. My worry, to be really frank right now, is that the current implementation deadlines, along with some of the narrowing, isn't taking into account the costs on the opposite side. So the cost to both businesses in the business ecosystem and to, of course, consumers, who, as Dr. Nanaki pointed out, it's their personal information that is at stake, of delaying the cybersecurity audits even more and so significantly. The SRIA was already really conservative on estimating benefits of the regulations, and I know they're hard to estimate in a lot of ways because it can, particularly for this, it can be the dog that hopefully doesn't bark. But that dog has been keeping everybody up at night for years, and it's getting louder, and it's becoming a pack. And yeah, I know I don't write things down. I don't know where I'm going to go. It's becoming a pack, and I'll just go further and say, and that pack is at the door. Our cybersecurity infrastructure security agency has been decimated. Cybercrime alone is estimated to have cost globally last year $9.5 trillion. That's trillion dollars with a T. $10.5 trillion estimated for this year, before the decimation of our national infrastructure for cybersecurity. This is a clear, present, ongoing, and quickly, rapidly growing danger. None of us wants to inadvertently make it harder for businesses to lock down their systems around personal information with requirements that aren't helpful. The first thing they have to know, though, is know where their risk is. That is the first thing they need to know. And the reason why I said that I'm concerned about our inability to estimate the costs of delay, et cetera, is in part because I think it isn't always clear in the discussion that this is a cost that ripples across the entire ecosystem. So I teach cybersecurity from time to time, and this is something that I keep track of pretty closely. Cybersecurity in the United States is provided by private businesses. you're on your own, like the way, not completely, well, more now, see above, CISA, but, you know, you lock your door, and it's a system that is, you know, requires businesses to realize they have the incentive to protect their crown jewels, and to protect the data of others they hold. It hasn't been wholly successful. As we all know, how many data breach notices has everybody gotten? And the issue is getting more and more acute because of the increasing number, amount, ease, and inexpensiveness of tools to attack these companies. And when I say it's not just the businesses, I should be more clear, businesses don't just pay the cost of the cybersecurity audit. They pay the cost of all their partners and everybody in their ecosystem, everybody in their supply chain, everybody in their service chain who doesn't do a cybersecurity audit and then has a breach or has, you know, ransomware attack that affects the entire ecosystem. So I see this particular issue as something that is acute, and what we need to do is give businesses the tools, and, you know, honestly, it seems they need a requirement. The tools to go ahead and kind of have the requirement underneath to understand what they're doing and to tighten up their requirements. So that's kind of the context in which I did look at this. So I would not support option 2. I'm very soft on option 1, but I'm willing to go with the board on it. And I'm very willing to, as probably was suggested by my question to Ms. Kim earlier, you know, if it's the case that we just, like, the no market is developing, that will help businesses do that, then we can talk about that then. But I think these are really paired to the bone. And I think that to the extent that we're getting comments that don't take into account the costs to the businesses doing the audits of other people not doing the audits, I think that we need to realize that that is a big missing piece of the puzzle. And the fact that they have a responsibility to protect the personal information in their care. I will go back to that genetics company that's just gone under. But there's also so many companies. They need to be capitalized to protect the personal information if they're going to handle it. So I hugely appreciate the work here. I'm really impressed by the cost profile, the cost savings you've been able to come up with. I just needed to state my concern about a direction, if it were a direction. With regards to the risk assessment, actually, I'll just leave it there and say I'm happy to share my thought about risk when it comes to things like public profiling. I do not think these things can be so easily distinguished, but I talked a lot about that in the last board meeting. The only thing that I will say about this is that it's only clearer that they cannot be so easily distinguished, and it's only clearer that there are actual physical personal freedom harms that are implicated by things like location data, things like whether you're at Target when your name was in the IRS database. And that in terms of HR records, I'll tell you, OMB protected them meticulously and took great care to maintain the privacy of those records. So I think, you know, Mr. McTaggart's point about Mr. McTaggart illustrates that there's a range of viewpoints about specific examples of things, and I would really value public comments on that. All right, now Mr. McTaggart, sorry, Mr. Liebert.
It could be Mr. Nick Liebert.
Yeah. Shoot.
I did take a couple of notes, so I'm going to look at some. As we once again consider what I think we all agree are some pretty dramatic narrowing amendments, as I would call them, to the agency's regulations. I too want to thank the amazing staff of this agency. And I want to give a special shout out on behalf of the board to our amazing legal staff. Wow. When we said just a few weeks ago, we need you to do a whole bunch of work in a really short period of time, what you did is truly extraordinary. And I bet you're very tired. So thank you for that. Thank you for all the staff who have been in this process. And thank you, my fellow board member, Mr. McTaggart, because I both congratulate you and blame you for all these hours and hours of work we're doing on this, because every word that you put in an initiative like that can lead to a whole bunch of conversation, and we have certainly proved that. Let's be clear. The state's nation-leading privacy laws are very clear in their commandments on the privacy protection issues we have considered today. With respect to cybersecurity audits, the voters clearly directed us to figure out how optimally to protect the privacy of California consumers by requiring businesses who have access to our personal information to conduct such cybersecurity reviews to ensure our private information is carefully protected. Thank you for that. With respect to risk assessments, the voters also clearly directed us to require privacy risk assessments that would include whether the processing involves sensitive personal information. So thank you for that. And yes, with respect to ADMT, the voters once again directed this agency to govern access and opt-out rights with respect to a business's use of ADMT. So we all need to recall as we grapple with these inherently complex, oh my gosh, and controversial regulatory efforts, that this has not somehow been an optional exercise. We have to do this. We've had to do this. The founding parents, which I refer to you, of these privacy laws, we are now operationalizing, including, of course, Mr. McTaggart, prudently gave us these important mandates. And I know we are all collectively striving to do our best to fulfill them, but the law requires us to do this. I suggest that looking back on the evolution of these draft regulations these past several years, the board has been unbelievably pragmatic and very open-minded in its rulemaking process. Perhaps too open-minded. We will find out. In that regard, as the chair has, I think, brilliantly noted, it is worth recalling just how much narrower and more cabined these proposed regulations before us today are compared to when the board commenced this effort years ago, which I was not part of. We have clearly listened carefully to the state's business and innovation sectors and their understandable concerns about the costs associated with protecting consumer privacy, their costs. And when we have listened to the public interest community and their reminders about the laws, what these laws require, we have to ask ourselves, have we gone too far in this balance? We don't know. This board, therefore, already has agreed to substantially narrow the definition of ADMT. It has agreed to narrow the definition of significant decision. It has agreed to a full-scale removal of behavioral advertising from the draft regulations reach, and it has completely eliminated the term artificial intelligence from the entire regulatory proposal, leaving it appropriately to the legislature to work on these challenging policy issues. And now staff is still proposing an even narrower construction of these regulations. For option number one, I would actually prefer to back it up a year, that we make things go a little bit faster. I think a couple of years to do this, if you're a billion-plus company, is plenty of time, and we've already been talking about this for 3 years. So that would be my suggestion, that we back it up a year. I think it can be done. We can always adjust these if we have to, but that's what my suggestion would be. I'm all for negotiating a reasonable set of regulations, and I know we've met that test. This is definitely reasonable, and I just hope we haven't gone too far. I say that especially in light of what's happening at the federal level. It's stunning. As the chair has noted, it is completely stunning. We are all sitting here, and all the people who are remote, wondering the same thing. Is all that information that's being stolen and shared at the federal level in violation to existing federal laws, does it make all of our work now moot? Because there's nothing but the sharing of our most sensitive personal information between all of these federal agencies. Where's it all going? That's before we even talk about the costs of cybersecurity attacks that we know are coming as our cybersecurity federal system has been completely dismantled. California has been an international leader in privacy to date, thanks to the work of so many, and of course this board as well. And I know we all believe we certainly should not stop that effort now. Folks, we are absolutely in a data risk emergency. And ours is the one state agency in the entire country tasked with doing the best we can here in California to try to prevent this onslaught. And so I want to congratulate this board, each one of you who have done, I think, just really, truly extraordinary work as well. And I'm prepared to support this proposal. I'd only ask that we consider as a board backing up a year. So with all of these narrowing amendments that we've done, I think it's entirely reasonable for us to expect that ramp up in a little bit faster time frame.
Thank you, Mr. Liebert. Other comments? So we have a few things that we could do procedurally. If there are other comments on the round of discussion, I did want to say something that I forgot to mention. Well, a few things, but I was trying to be brief. One is the relationship of the current draft regulations to the legislature's activity, which I think Ms. Mahoney's presentation earlier was extremely helpful in, again, kind of getting a sense of a snapshot of the legislature's activity in this area right now. And I really appreciate that the legislature, you know, in some places, I understand, you know, it's a little messy, and, you know, maybe they need to do some thinking about where they put certain responsibilities, absolutely. But it is appropriate for the legislature to be addressing sort of things on a moment-to-moment basis. And with the regulation sort of streamlined and going 120 miles an hour at this, wow. Is that AI?
No. Someone asked me for a link. Sorry.
It's like the worst example of hearing your own voice, having it like echo. I don't sound like that, please. Anyway, that the agency has a baseline version of what we are required to do in our statute, that again, we can amend in response to what the legislature is doing. But at this point, it is very much sort of a foundation, and the legislature is moving beyond that, it sounds like, in a number of significant respects. So I think that is an auspicious place to be. And I appreciate the thoughtful work to do it. I did want to say a word about the pre-use notices being explicitly allowed to be included in the notice of collection. I read the regulations as the draft regulations as they were to allow that before. Making explicit is sort of fine with me, but I wanted to point out that we removed behavioral advertising as a threshold last time. And the most compelling version of the concern I heard about pre-use notices at that time related to that particular use. So I just want to voice not exactly a concern, but an observation that it will be important, should companies choose to embed a pre-use notice within their notice of collection, that it is truly available to the consumer, that they truly understand the proposal to use automated decision-making technology, that it exists, what it's for, and that they have those rights of access. It is important, you know, to be sure, as Mr. McTaggart described, you know, really eloquently, you don't want to have, I don't remember if he used the word proliferation, but you don't want to have a proliferation of notices flying around your head, and you can't really, you also don't want important stuff to be buried in a bunch of text that you can't really follow. And so I would certainly value public comment, sort of guidance on, I don't know, comments or background information the board could provide on that. Thank you. So I know that staff were hoping to be able to respond to some of the questions about costing out the various timelines. We now also have on the table Mr. Liebert's potential pullback by a year. Mr. Liebert, are you comfortable asking staff if they have cost for that? Yeah. And if you don't, okay, sorry.
We're not
That was-
prepared for
was
that one
not-
today.
That was not.
Madam Chair, can I ask Mr. Liebert a question? So are you talking then of only of pulling back the 1 billion, still having a threshold between 1 billion and 100 million? So 1 billion would come, so 1 billion would be 2027? And then 100 to 1 would be 2028?
Okay, so we may not be able to get an estimate exactly on that, but we can expect that that particular cost profile will go up. And the cost profile that on the other side that I mentioned that hasn't been costed out exactly and probably can't be will go down, but we don't know precisely the magnitude.
So I just wanted to comment on that, just to reaffirm that, yes, with the pushing out of the direct costs to the business, there is a delay in the benefits, especially the quantifiable benefit when it comes to cybersecurity crime. I think we have some preliminary ideas about how it may go down, but I need to double check and see if that's.
I really, and on that point, I wasn't asking for numbers that I know are very difficult to produce. I just wanted to be sure that people kept in mind that the math here is incomplete. And it is incomplete in ways that may not be expected if you're not the folks who think about this every day within a company, for example. The one last thing is I'm okay with changing the board notification provision or the board sort of. I will say that I think that is a valuable provision. I understand the objections to it by businesses, but one of the big issues with cybersecurity has been that it was really hard to get C-suite's attention because of the fact that it tends to live in the IT department. And when you get to the C-suite, you don't have anybody who understands it very well. That's not true anymore, I don't think, but they would think of it as a cost center. And you know, you kind of want your board to know if there's a big old risk hanging out there, you know? So I think there was real substantive value in that, but to ease implementation for businesses and to be sure that we are, you know, driving, we have a sports car, I'm happy to go ahead and support that. All right, so given that staff need, yes, Mr. Liebert.
I just wanted to say how helpful it was for you to mention about impacts on consumers, about cyber attacks. We've all gotten these letters of the data breaches, but we know nothing about what that really means for us, right? It's very difficult for us to ever quantify in any way, what does that harm mean with our information out there in so many ways? And you get that notice about that your name's just been found or your email's been found on the dark web. Most people don't know what the dark web is. I understand that. So I would like to encourage that when we have these conversations, that we think about those costs as well in a more direct way than frankly we have staff at this level. We tend not to talk about that. We just focus on what are the costs per business. As I understand it, under the current option 1, it probably is somewhere, maybe you can help me, Ms. Kim, on this, but somewhere in the number of maybe $20,000 per business to comply with the cyber audit requirements. Is it something like that? Maybe Phil.
I might jump in to just say,
Yep.
I think you know I think that understates probably the SRIA, which really tried to identify a range of possibilities.
All right,
But if
what
you're
would it
doing
look like?
But if you're doing simple math of
Yep.
this many businesses and this is the cost,
Yep.
you're not wrong that it's
Somewhere in that
about
neighborhood,
right.
20, 30, whatever that would be, which is less than a lot of employee costs per year to try to address these concerns. So I only say that because I think it would be very, very helpful for us to have that component in our conversations too about the impacts on consumers.
Because so much of the cybersecurity infrastructure is, and for important reasons, right? We have a private infrastructure that's distributed across private entities, and that is incredibly valuable and important for the market and frankly for democracy to have that kind of construction. I'm editorializing a little bit here, but there is a lot of weight on businesses' shoulders. And one of the things that is the case is that, especially until recently, and now again, I suppose a lot of the reporting and estimates on costs and things come from respected private parties. So Verizon does a report every year, Mandiant does a report, IBM and Ponemon Instrument together do a report, and IBM Ponemon's estimate for what the cost to a company of a data breach is on average last year, $4.88 million was the cost of a data breach, if that's helpful. Okay, so I know you all have agreed to do some more homework for us. Thank you very much. I suggest that if people are amenable, that we take lunch. Yeah, sure.
One more question for Mr. Liebert. Your desire to move it back earlier is just with respect to the cybersecurity, is that correct?
Yes. And I'm open, by the way, to answer your question. If the board doesn't want to do this, I totally can understand. I'm open to that persuasion. I just am concerned that we've been at this for a long time. We've got a pretty long ramp up under this scenario. And certainly for the very, very, very large companies, you know, this doesn't seem like it would be too onerous, but I would certainly defer to the board in that ultimate decision.
Thank you, Mr. Liebert. Mr. Worth.
I think the fact that you're proposing to advance backwards or forwards, advance backwards option 2, effectively gets us to option 1 other than the companies that are over $1 billion. They're the only ones really impacted by coming 1 year earlier. So I didn't want to go to option 2 anyway, so you're basically getting back closer to where I wanted to be, so I'm supportive of it.
Okay. All right. Let's go ahead and take lunch. And I am actually so sorry. Pause. Don't leave, everybody, on the public meeting on Zoom. I apologize. I misspoke because I first need to call the. I first need to set aside this agenda item for the moment. We will recall it imminently when we come back from lunch, but we do have a closed session agenda item with a number of aspects to it, and has been our practice, we will take that up during lunch. So I will now call up and open the closed session agenda items, which include personnel matters under Authority of Government Code Section 11126A1, and administrative enforcement matters, which is pursuant to Government Code Section 11126C3, which authorizes discussion and deliberation on these matters. And finally, pursuant to Government Code Section 11126E1 and 2A, the board will confer and receive advice from legal counsel regarding litigation for which disclosing the names would jeopardize the agency's ability to conclude existing settlement negotiations to its advantage. I anticipate that we will be back by around 1:30, but I'm going to just say that we won't be back until 1:30 in order to allow everybody who's here from the public and also staff to know that the board's not going to get started again before that window closes so that people can make their plans for lunch or whatever they need to do. Thank you. With that, the board will go into closed session. Welcome back, everyone. The board has now returned from closed session on Thursday, May 1st at 2:06 p.m. And I am going to recall to the discussion agenda item number 4, which is discussion and possible action on proposed regulations regarding automated decision-making technology, risk assessments, cybersecurity audits, insurance, and updates to existing regulations, including possible modification of the text. Welcome back, everyone. So when we went into closed session, as I understand it, we had board members ask questions and offer comments, at least in a first round, and staff were planning to take a quick look at some of the questions that we asked, especially with regards to the cost differentials for different delay of implementation timelines for the cybersecurity audit regulations. I think that Mr. Liebert has a question. Would you like to ask it before they start?
Sure, absolutely. Thank you. Maybe it's a two-pronged question. The first was, as you know, I raised the possibility of moving things up by a year. So there was a, excuse me, question regarding cost implications of that. And then the second, which I'm adding now, is as anxious as I think we are to kind of get things moving so we can get these protections in place, is just how viable that is with the rulemaking process, the process itself. So I'm wondering if it's realistic to think about doing that in the context of things that might happen along our journey now that might be potential impediments as well, not giving businesses enough time to adjust, if you will. So I wanted to throw both of those out, please.
Hello, testing. All right, there we go. Yes, so happy to respond to that. As we understood the proposal, it was essentially to take option 2 and bump it up a year for all categories of when you would begin doing your cybersecurity audit, which would mean the first cohort, the 1 billion and over group, would have to complete their first cybersecurity audits by January 1st, 2027. So with that in mind, in terms of what I can do is map out best and worst case scenario in terms of the speed at which we might have regulations in effect here in California. If the board were to move on to a timeline where we go out for public comment after today, we come back in July and the board decides actually we nailed it, these regulations are the one we want to adopt, and then we submit to the Office of Administrative Law at that point and they are approved. It means these regulations could be in effect as early as mid-fall, essentially. I'd say around September, October. But that's one scenario. If, for instance, the board determines another round of modifications are needed or sort of other issues come up that delay sort of final adoption and submission of these till later in the fall, then we would end up in a situation where potentially we're getting a decision from OAL at the very end of the year. And then, as was alluded to earlier, if that decision were disapproval, then we'd have 120 days to cure. And I know that sounds like a lot, but knowing the board would need to approve the modifications on the front end before we go out to public comment, and then we need to come back, having considered those new comments, and adopt, then re-adopt essentially any modifications made to those regulations. I think we're looking as late as April 2026, essentially. Meaning that's about 8 months before then that first cohort of $1 billion or over $1 businesses would be required to complete those cybersecurity audits. One more thing I'll mention is then an option in terms of how we would construct that is we could either say the effective date of when your audit needs to harken back to could be the effective date of the regulations, right? So instead of making it a whole year, it would be maybe the 8-month spread between April 2026 and the end of the year. Technically, you could also still have it apply for the whole year. So there'd be some options, but this is all to say, I think to the point you're asking, Mr. Liebert, is the amount of advance notice that businesses will have will depend a little bit on how quickly we do have final adopted regulations have been approved.
So it could be as short as in the worst case scenario that you've outlined, although in the chart it says April 1st, right? Or are we talking January 1st?
Oh, yes, yeah.
So under that scenario, under the worst case scenario, would still be about a year if they were in place by the April of the preceding year?
That's a deadline for when they have to report back to the agency that they completed the audit, but that is correct.
So it'd be about a year?
Yeah.
Okay, thanks very much. And then I guess I should go to that second question.
Actually, Ms. Anderson, did you have additional information, or did I misread the?
I was
leaning
just
towards the
making a
microphone.
Slightly nuanced point of the audit period is generally from January to January, and then there's 3 months after that audit period concludes for the business to be able to complete its report of the audit. So that's the difference between the January and April 1st is just the time to actually complete the report itself. But the audit period, what as Phil was mentioning, it could either be from January to January, or if the regs didn't go into effect until later than that, the audit period could be shortened and they would still have the amount of time to complete the audit report.
I'm very bad at math. If what I think you're saying is, yeah, I think what you're saying is that it could actually be a year and 3 months then, right? It just depends. It just depends.
Perhaps the point made is when you do an audit, the audit looks at a specific period of time. So if the period of time that the business is auditing went beyond when these regulations went into effect. I think that's actually fair game and on the table for this board to consider. But I also think there could be an option to limit that initial scope, basically saying from the date these pass to the end of the year is the audit term, and then the audit report reflects that.
So they'd still have, under that scenario, Phil, a potential year to do it?
Yes.
Got it.
I would point out another piece of nuance, which given how long we've been at this is not so much nuance anymore, which is that there has been a lot of notice of these regulations, and there will be a lot of notice while the board continues to deliberate and we wait for OAL to act. So I think that's also just, a realistic fact to note. Mr. Barth.
So I think I withdraw my support for your idea, and I go back to option one for this reason. April 27 is your audit due date for the calendar year 2026. You can't go get an auditor on board without a scope. I mean, unfortunately, that's just their world. Exactly what do I have to do? So until we have everything in finalized, could you actually go for an RFP to get somebody on board? So I'm back to the 20, would be 2028 versus 2027. That's my feeling.
I think I've been convinced as well. That's why I asked the question.
Right.
Yeah.
Yeah, that's also a very good practical point. How are you going to bid if you're going out for a contract? Great. Okay. You've already wowed us, so I won't put any pressure on you to wow us again with like how well you've managed to answer this question in an hour. But please go ahead.
Well, I think a lot of the questions had to do with the economic assessment and just like the shifting of times and dates. I given that there's no longer just like I won't belabor the point about Mr. Liebert's options. What I did want to point out with regard to the total cost over 10 years for option one versus option two, it's actually a very minimal amount difference. Option one would be 5.1, let me see, 5.1 billion over the course of 10 years, as opposed to option two, which would be 4.9. So it's over the course of many years, that's not that significant, according to our economists, I can say that. And just to put it in light of what the original costs were for cybersecurity, it was 9.7. So there's already a significant drop down. Also, with regard to giving some fee, answering the question of what the cost of a cybersecurity audit is per firm, it varies depending on the size of the entity. And this is because of the assumptions the economists made with regard to if you're a larger company, you have a more extensive cybersecurity program, and you're more likely to use outside auditors to audit your cybersecurity program, which is if you're making over 1 billion, the assumption is that you're going to go for the higher end auditors, whilst if you're in the 100 to 1 million to a billion, less. And so with that calculation, I think the estimated cost per firm for those entities that are under 100 million is around $29,000. And then for that middle range of 100 million to 1 billion, it's 78,750. And then with regard to those firms that are larger than $1 billion in revenue, that's $190,000. That's the estimates that our economists have at this point. Then also, I want to make the point of the benefits. In our Sharia, we do have a portion of our benefits section that talks about quantifiable benefits related to the reduction in risk of cybercrimes. That has been calculated with regard to our risk assessments and cybersecurity audits as being a 12.6% reduction of cybercrimes. And that estimates to be approximately 1.5 billion in 2027, 66.3 billion in 2036. But with the delay, it would be basically the calculation would be 12.6 percentage reduction per firm delayed by that year. So for one example, if we went with option one, in the first year, the reduction in benefits, and this is not accounting for present value or any of that stuff, would be 26.8% less And then in the second year, it'd be 68%, and then it wouldn't be until year 3 that you would see that 100% of the benefits. With regard to option 2, in that first year of benefits, you'd only see 2.24%, reduction in cybersecurity crimes, and then 26, and then 68 and 100%. So there is a significant delay depending on how you phase out these benefits. That is what I have for right now. I'm happy to answer any additional questions to the extent I can.
Thank you. That seemed very clear to me, but I did not ask the question, so I'm looking at those who did. Yes, Mr. McTaggart.
I think there's probably not a lot of appetite on the board here for this. I just think that probably if I look at the benefits and the cost, it just strikes me as probably most of the cost and benefits are in the bigger companies. And the problem I just have, I guess I should always remind myself that there's that threshold for data broker, but less than 50 million, it's $30,000 a company. That's a lot of money, So I'm thinking if that got delayed a year, it might not hurt privacy so much. But at the same time, I'm not sure if people are really going to.
Yeah, I mean, so a couple things. One is there are multiple thresholds that, again, reduce the number of businesses affected. Number 2, it is an ecosystem, and we are already not capturing a lot of the vectors across whom these threats come, a lot of the vectors. It's just a very difficult problem to solve, and I think this is a good start. The businesses that can absorb this easily have an incentive, indeed a requirement, to audit their practices in a rationalized fashion, and it's a start. It's a good start. Okay, wonderful. So there will be opportunity if folks have additional sort of items that occur or things that occur to them. But at the moment, I will preview the possible motion that I intend to request after public comment, which would be to direct staff to take all steps necessary to prepare and notice modifications to the text of the proposed regulations for an additional 15-day comment period. The modification shall reflect the changes proposed by staff in the written meeting materials, except staff shall further modify the text in line with today's discussion to be aligned with any revisions from today's discussion. I think we had mostly questions rather than specific revisions, but we did, I think I heard mostly consensus on option 1 on the timeline for the cybersecurity regulations. I also note that the board has been discussing the actual number of days in the legally mandated 15-day. But I think that we could return to that if we have additional guidance for the board after we have public comment. If Mr. Laird tells me that's okay.
Yes, that's perfectly fine. My only thought is before we wrap this up at some point today, we might want a little bit more clarity. A few of the issues brought up on just what the expectation is and how we're going to notice the text. But I can address that after public comment. That might better inform those final decisions.
Sure, or we could do it now.
Essentially, I think there was a few issues raised specifically in terms of potential revisions for to be considered for modifications. I do think I also heard at times the board thinking we start with this, hear public comment, and then come back to those same issues. So we're happy to defer to either approach, but if there's anything we should
Yes,
discuss.
my apologies if I got that wrong. I was operating on the second assumption, and indeed after public comment was going to, or I guess could say that I understand that there are some questions on the table that we value all public comment, that we would particularly value public comments in. For example, the question of ensuring once the public will understand what the purpose of that is, and we'll get some comment on that hopefully. I assume staff will work to clarify the language around profiling and align with Mr. McTaggart's comments, and then we'll get comment on that, or we could just, we could get comment on it. I don't feel strongly about it, other than I think that some of these items would benefit from staff having time to just sort of think it through. But I should make sure, Mr. McTaggart, I'm not rolling over your thinking here.
No, I had a nice chat with Ms. Anderson and Ms. Shake over the break, and I think that we all kind of understand where we're kind of trying to head, and we're gracious enough to not completely mock my comment with respect to profiling. So I think they're going to look at it, and we all want to cover what should be covered and not cover what shouldn't be covered.
Okay, great. We do have some softness on what the board thinks should be covered, but those were all May items, so.
Okay, I think. So that's great, thank you. So just to clarify, because as you can imagine, of as much as we can nail down now is that it will leave open the option in July that this board actually adopt this version of these regulations if you feel convinced that we've struck the right balance. I guess I just want to confirm, does staff have flexibility to notice modifications that include some?
Oh, I thought so.
Okay, great.
I meant that to be built into the motion.
Perfect. Okay, I just wanted to make sure I was abundantly clear on that. Okay, fully understand now.
Yes, prepare and notice modifications to the text.
Great, thank you.
Okay. Wonderful. Ms. Marzian, is there public comment?
Agenda item number 4, discussion and possible action on proposed regulations regarding automated decision-making technology, risk assessment, cybersecurity audits, insurance, and updates to existing regulations, including possible modification of text. If you'd like to make a public comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. Again, this is for agenda item number 4. It looks like we have some comments in the room first.
Good afternoon. Good afternoon, members of the board. I was just in the neighborhood. I thought I'd just drop by and see how you guys were doing.
Thank you for coming.
Not a problem at all.
We are delighted to see you.
Of course, yes. I'm P. Anthony Thomas. I'm managing director for the Thomas Advocacy Group. And let me just say that I've been to a few of your meetings, members of the board and staff, and it is an awesome responsibility to capture privacy protection in and of itself. And of course, all you have to do is attend one of these meetings to find out, and your head will be spinning. So I have plenty of Excedrin for you guys, just in case, anyway. But the reason I'm here, members of the board, is that it has to do with the concern about the economic impact to small businesses. And I know that you deliberate, you do the best that you can in every way that you can to make sure that those things don't impact small businesses too ardently. But I'm just here to reiterate that the regulations to small and diverse businesses in the state since the beginning of this board and this process cannot be ignored on what they do after you make your decisions. As I said, in attending current and past board meetings, it could harm small businesses in the state of California. I believe the governor even referenced something in his recent comments about the agency regulations and possibly indicated this. I believe that board member McTaggart has been saying this for some time, and capturing Prop 24 created the agency to regulate privacy, not necessarily AI. I have to give you compliments on last month's meeting. The agency considered several changes to the proposed regulations that are supportive of the new definition of automated decision-making and technology. Kudos to you guys in the work that you're doing and the removal of behavioral advertising, ADMT, and risk management, of course. Also, if it hasn't been the request to remove AI, it should be. This is probably where you get to the push and your pull of your discussions, but remove ANI from this regulation and find a way to scale down the economic impact to small business, I think will be in the best interest of all of us as Californians. Again, board members, you have an awesome responsibility. I salute you for what you're doing, and staff, as a former staff member, I bend to you and say thank you. And you guys, thank you for my time today.
Thank you very much.
Hello, board members. Thank you so much for the opportunity to give public comment today. I'm Danny Kando Kaiser. My firm, Kaiser Advocacy, represents the Electronic Frontier Foundation as well as Consumer Reports. I have two brief statements of both of them. So Consumer Reports is a nonpartisan nonprofit with millions of members nationwide and more than 175,000 members in California alone. Every day, Californians are being evaluated for rental units, mortgages, health services, job opportunities, and spots in top schools by automated decision systems. These predictive algorithmic systems may in practice function poorly. They may latch onto factors that tend to correlate with the desired outcome, but are not in fact important. For example, a hiring algorithm may notice that in the past, a company was more likely to hire applicants with bookshelves in the backgrounds of their video interviews. The algorithm may therefore rate candidates highly in part based on the presence of a bookshelf. This is a real example. AI hiring company Retorio was found to work precisely in that way. Everyday Californians are completely in the dark about their personal data and how it's being repurposed to make these decisions. Moreover, it's clear that the public wants companies to be required to explain how these systems work. Nationally representative surveys that Consumer Reports has commissioned show that a majority of Americans are uncomfortable with the use of AI or algorithms to help determine the exact kinds of decisions these rules would cover. Overwhelming majorities want to know specifically what information about them a system uses to make a decision, and that cuts across all demographics. There is overwhelming public support for transparency and recourse when automated systems make important decisions about consumers. Because the new draft rules were only posted yesterday afternoon, we've not yet had an opportunity to go through with a thorough analysis. Still, it seems the agency has moved to weaken important definitions, like the definition of automated decision technology, among other significant changes. We're also disappointed that the updated regulations remove the requirement for businesses to create an abridged version of the risk assessment that was made publicly available. Businesses' assessments of the trade-off between the risks and the benefits of their processing of personal data should be public information that consumers can use to weigh their involvement with a given business. Under the current draft, instead, they'll be buried in a document that very few will ever see. We fear these changes weaken the rules and push in the wrong direction, and we would ask the board to reconsider and at least grant a 45-day period to review and comment on these significant changes in writing. And again, just very briefly, on behalf of the Electronic Frontier Foundation, which is a nonprofit devoted to protecting civil liberties, including privacy and innovation, like many privacy advocates, we have considerable concerns about how these proposed rules narrow key protections. While we have not had time, also EFF has not had time to evaluate all the alterations fully, changes to key definitions and requirements significantly reduce not only protections, but everyday consumers, but also their ability to act in their own private interests. California's voters created this agency to protect their privacy. They understand how important and difficult it is for them in this moment to control how companies use their personal information. They knew they needed thoughtful rules crafted by the people who understand the landscape to help them do so. The latest draft of these regulations represent a significant retreat from this agency's mission. We understand the goal of ensuring regulation is not so onerous that it stifles innovation. However, we urge the agency to stand strong against industry demands to hollow these regulations out, and first uphold its central goal to protect Californians' privacy. Thank you so much.
Thank you so much. Thank you for joining us today. Ms. Marzian, are there public comments online?
Yes, we have a few hands raised. First, Edwin Lombard, I'm going to unmute you at this time. You'll have 3 minutes. Begin when you are ready.
Yes, good afternoon, Madam Chair and board members. My name is Edwin Lombard with ELM Strategies. Again, I'm here representing the California African American Chamber of Commerce, a number of ethnic and minority small business groups and local chambers throughout the state. As you're aware, for a couple of years now, the organizations that I represent have been concerned about the economic impact of the CPPA regulation to small and diverse businesses in the state. We have said all along that CPPA regulations could harm small, diverse businesses in California. And with that, I would like to repeat Governor Newsom's recent comments about CPPA regulations, and I quote, "Enacting these regulations could create significant unintended consequences and impose substantial costs that threaten California's enduring dominance in the technological innovations," end quote. And I'd like to thank Board Member Alistair McTaggart for his steadfast push to make sure that Proposition 24, which created the CPPA to regulate privacy and not AI, that he consistently speaks on this and works towards making sure that that happens. In the last month's CPPA hearing, you considered several changes to your proposed regulations, which we believe is a step in the right direction if adopted. And we are supportive of the new definition of automated decision-making technology and removal of behavioral adverse advertising for ADMT and risk management. California's budget situation is precarious. Adding billions of costs to small businesses and driving jobs out of the state is ill-advised. I would like you to take these thoughts into consideration, and I thank you, and we look forward to continuing working with you so that California's privacy regulations are reasonable and balanced as required under Prop 24. Thank you.
Thank you, Mr. Lombard.
Next, we have Julian Kennett. If I'm going to unmute you at this time, you'll have 3 minutes. Please begin when you're ready.
Thank you, and good afternoon, CPPA board members. Julian Canetti, President and CEO of the California Hispanic Chambers of Commerce, and thank you for the opportunity this afternoon to address you. The Chamber membership includes over 130 Hispanic and diverse chambers of commerce and diverse business associations from throughout the state, representing the interest of over 950,000 diverse small businesses. On behalf of our membership, we appreciate CPPA's efforts to hear our concerns about the proposed regulations. At last month's CPPA meeting, the agency considered several changes to its proposed regulations, which we believe is a step in the right direction if so adopted. We are supportive of the new definition of automated decision-making technology and, of course, the removal of behavioral advertising from ADMT and risk assessment. However, we continue to be concerned about the inclusion of AI in the regulations and the significant cost to small businesses. We agree with Board Member McTaggart. Proposition 24 was created as a CPPA to regulate privacy and not AI. We would also like to reiterate, as others have, and echo Governor Newsom's recent admonition about the CPPA regulations, and that enacting these regulations could create significant unintended consequences and impose substantial costs that threaten California's enduring dominance in the technological innovation field. In closing, we believe that the changes we are asking for, if so adopted, are steps in the right direction and will help minimize the impact to small businesses in California. Again, I appreciate your consideration of our testimony today, and thank you for the opportunity.
Thank you, Mr. Canetti. I don't usually do this, but is it all right if I clarify? Thank you. I feel a point of clarification is in order, just so commenters know this. All references to artificial intelligence have been removed from this draft. They were removed following the board's conversation on April 4th when we decided to recommend that to staff. Thank you very much. Ms. Marzian, are there further public comments online?
Yes, there are a few more. Swati Chintala, you'll have 3 minutes. Go ahead and begin when you are ready.
Good afternoon. My name is Swati Chintala, and I'm sharing these comments on behalf of Tech Equity. We're deeply concerned that if the board continues with this extremely narrow definition of ADMTs, an employer could self-certify itself out of coverage by claiming that a given automated system does not substantially replace human decisions. The revised definition does not even require meaningful human involvement or review, giving a free pass to businesses that pressure workers to rubber stamp automated decisions. As the preliminary assessment shared today indicated, this narrowing would allow almost all companies to avoid the accountability that the CPPA was charged to develop through its regulations. We are deeply concerned that a board mandated to regulate and protect the public would enact rules based on pressure from the industry that they are regulating that would exempt 90% of the industry. Organizations that represent the communities and workers directly impacted by the collection and use of personal data do not have the enormous resources available to companies and their associations who have used everything at their disposal in an attempt to delay or outright stop this process. We urge the board to act today to address this huge imbalance in power and resources rather than put their thumb on the scale in favor of big business. We have additional concerns about how the proposed regulations have been narrowed. However, a 15-day comment period would be unreasonable to allow community organizations and workers to democratically contribute to this process. The board should provide for a 30-day comment period, given the major changes that were shared just yesterday. California has been leading the way on privacy protections, but if the board chooses to significantly weaken these protections, you risk setting a lower bar and eroding workers' and consumers' privacy and digital rights, not only in California, but also across the country. There have been an effort to oppose nearly every proposal to set clear frameworks for the use of ADMTs in the California legislature as well as other states. Importantly, this effort cannot be divorced from the deregulatory effort we see playing out in Washington, D.C. The agency has proper democratic authority to protect Californians from privacy harms. We urge the board to use it. Thank you to the CPPA director, staff, and the board for your important work.
Thank you.
Cheryl Brownlee, I'm going to unmute you at this time. You'll have 3 minutes to make your comment. Go ahead and begin when you're ready.
Good afternoon, CPPA board members. I am Cheryl Brownlee, representing CB Communications and many women small business organizations. The small business organizations I represent have been concerned about the economic impact of the CPPA regulations for the last few years. And we have demonstrated that by being at the hearings, if not in person, but via Zoom, which we appreciate that you've afforded us that opportunity. We have always expressed our concern that Proposition 24 created CPPA to regulate privacy. We thank you for removing the AI portion of this in the information and the clarification, Chairwoman, that you just recently made. We believe the new definition of automated decision-making technology, ADMT, and removal of behavioral advertising for ADMT and risk assessment discussed in last month's CPPA meeting is a step in the right direction. We are also concerned about the added extreme costs of doing business for small businesses here in California, and we feel that this could drive jobs out of California and is ill-advised. And as well, we agree with the Governor Newsom's recent comments about CPPA regulations, and just as other of the people discussed earlier, his comment. I thank you for allowing me to speak today, and I appreciate it.
Thank you very much.
Kara Williams, I'm going to unmute you at this time. You'll have 3 minutes to make your comment. Go ahead and begin when you're ready.
Hello, my name is Kara Williams, and I'm a lawyer at the Electronic Privacy Information Center, or EPIC. EPIC is an independent nonprofit focused on protecting privacy in the digital age. EPIC was very disappointed to see significant weakening in the latest draft regulations on ADMTs, risk assessments, and cybersecurity. Strong rules are essential to ensure that Californians are protected from the well-documented harms to privacy and civil rights caused by the unchecked use of automated decision-making technologies. The original draft regulations would have been a significant step toward this goal, but with each new revision and increase in pressure from the tech industry, the draft rules have become less and less protective for consumers. The California Consumer Privacy Act and the voters have tasked this agency with adopting regulations that would protect their right to privacy. And as the only dedicated privacy agency in the country, this body is in the best position to develop thoughtful, well-crafted rules that meaningfully protect privacy, especially as the increasing use of AI presents new and pressing harms. Privacy harms include the harmful use of personal information in automated decision-making technologies, and the CCPA clearly authorizes the agency to regulate ADMTs to protect California consumers. EPIC urges the agency to push back on industry's attempts to weaken these regulations and instead restore the protections from earlier drafts to fulfill the agency's mission to safeguard Californians' privacy. EPIC would also ask that the comment period be extended beyond 15 days to ensure we and other advocates can thoroughly review the numerous changes and provide comprehensive feedback to the agency. Thank you for your time and consideration, and EPIC is happy to remain a resource for the agency.
Thank you.
Mark Jacobs, I'm going to unmute you at this time. You'll have 3 minutes to make your comment. Please begin as soon as you're ready. Mark Jacobs, you are unmuted. Please begin when you're ready.
My apologies. Thank you very much for your time. Really appreciate it. My name is Mark Jacobs. I represent M&S Holdings, a consulting group located here in Sacramento. Many times we have said that CPPA regulations could harm small businesses and diverse businesses in California. We are deeply concerned about the economic impact that the regulations would have on these businesses. Proposition 24 created CPPA to regulate privacy, not AI. To that note, we agree that the Governor Newsom's recent comments about the CPPA regulations and wishes would take them into heart. Quote, enacting these regulations would create a significant unintended consequence and impose substantial costs and threaten California's enduring dominance in technological innovation, unquote. We would also like to thank Board Member McTaggart for his steadfast pursuit to see that Proposition 24 be regulated as designated. We support the new definition of automated decision-making technology, but however, CPPA must remove AI from regulations to find a way to scale down the economic impact of CPPA regulations to our businesses, of which was earlier, and that was greatly appreciated. California's budget situation is precarious. Adding billions of dollars to the cost of businesses and driving jobs out of California is an ill-advised and inappropriate result. Thank you very much for your time, and we look forward to continuing to work with CPPA and California privacy regulations to reasonably and balance as required under Proposition 24. Thank you for your time.
Thank you.
Bryn O'Neill, I'm going to mute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Good afternoon. I'm Bryn O'Neill, Regulatory Policy Specialist with the California Nurses Association, a labor union representing over 100,000 registered nurses across the state. We respectfully urge the board and agency to restore the regulatory draft from April and to strengthen it. As we have previously, CNA urges again today the adoption of regulations that are broad in scope and broad in the tools provided to workers, patients, and other consumers in the protection of their privacy. In healthcare, ADMT-enabled processes of surveillance, routinization, and interference with professional judgment of clinicians threatens the provision of safe therapeutic care. Algorithmic technologies are making life and death decisions on healthcare and working conditions. They are impacting the lives and livelihood of millions of patients and workers every day. Patients and workers are in dire need of these regulatory guardrails. It's important to reiterate that this agency is lawfully mandated by the voters to issue regulations to protect consumer privacy, including worker privacy, from harmful collection and use of their private data. It should be considered a failure of this mandate if CCPA regulations do not ensure that consumers and workers have the ability to understand when and how their private data is being collected or used, and importantly, to address any harmful collection or use of their data. The original draft of these regulations would have taken important steps to meet this mandate, but the proposed modifications, so far as we've been able to review them, reflects an undue desire to protect tech companies, deployers, and their business interests, rather than protecting workers, patients, and other consumers across California. More specifically, we're deeply concerned about the changes to the definition of ADMTs to include only those that substantially replace human decision-making. This change allows employers and other corporations to easily opt themselves out from the rule's reach by simply claiming that an algorithmic tool is only advisory to human decision-making. In practice, workers who use ADMTs often have no real choice but to follow the recommendations of the tool for fear of employer retaliation. That this change would result in only 10% of CPPA-regulated businesses being subject to the rule should be seen as a dereliction of this agency's duty to protect worker and consumer privacy. To close, California is the only jurisdiction in the country where workers have a right to privacy in the workplace, and it is profoundly important that this agency and California lead the country in the protection of workers and patients against harmful collection and use of their data through algorithmic technologies. Thank you.
Thank you.
Michelle Khan, I'm going to unmute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Good afternoon. My name is Michelle Khan, and I'm giving comment today on behalf of Annetta Bernhardt, the director of the Technology and Work Program at the UC Berkeley Labor Center, where I also work as a senior researcher. Our program's goal is to provide the research and policy analysis that stakeholders need to ensure that AI and other digital technologies benefit and do not harm workers. For union and non-union workers alike, the emergence of AI and other data-driven technologies represents one of the most important issues that will shape the future of work in California for decades to come. Employers in a wide range of industries are increasingly capturing, buying, and analyzing worker data, electronically monitoring workers, and using algorithmic management to make critical employment-related decisions. And yet, California is the only place in the US where workers are starting to gain basic rights over their data and how employers use that data to make critical decisions about them. That is why labor groups and other worker advocates have invested significant time and effort to provide detailed and empirically based recommendations about how best to protect workers in the agency's rulemaking on ADMTs and risk assessments. My team and I have not had the chance to do a full and thorough analysis of the revised draft regulations, but based on our reading so far, we are very disappointed to see significant weakening in both the definitions and the substantive provisions. In particular, our concern is that the continued weakening of the ADMT definition will effectively allow employers to self-certify themselves out of coverage by the regulations. As we and other advocates argued in our January 9th letter earlier this year to the board and agency staff. The California Consumer Privacy Act and the voters tasked this agency with adopting regulations that would protect them from harms in the collection and use of their data. As the only dedicated privacy agency in the country, this body is in the best position to develop thoughtful, well-crafted rules that meaningfully protect consumers and workers, especially as AI is being increasingly used and presents new and pressing harms. I respectfully urge the agency to reconsider the current path towards weakening regulations and instead restore stronger protections from earlier drafts. Thank you for this opportunity to comment.
Thank you.
Fred Soletto, I'm going to unmute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Thank you so much. My name is Fred Sotelo, and I'm a proud small business owner and a member of the California Hispanic Chamber of Commerce and founder of San Diego Latino Professionals. Small businesses like mine face significant challenges when it comes to responding to burdensome regulations. Unlike larger corporations, we lack the resources, both financial and human, to navigate these complex regulatory landscapes. This can lead to increased operational costs, reduce our competitiveness, and even the risk of non-compliance. You know, we may struggle to allocate the funds for this compliance, auditing, and the implementation to any changes that affect how we will use this technology. And it's really taxing on our limited budgets. We understand and agree that regulation to protect consumers is first and foremost. As a small business owner, no one understands their consumers like we do. We touch them, interact with them, we value our customers. I mean, every single day, they're our lifeline. But we also would like to just convey that the committee just take into consideration of small businesses like ourselves when you're making final decisions, because we aren't big business and we just do not have the resources for burdensome regulations. So our hope is that as you create regulations to protect those in both our customers, our consumers, but you'll also find a medium that's going to also not hurt us small business owners. Thank you for your time. We appreciate you greatly.
Thank you.
Ronak Dalami, I'm going to unmute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Thank you. Thank you, Chair Urban. Ronak Dalami with Cal Chamber. Since September 2023, we have spoken at every board meeting on largely the same overarching concerns on these draft regulations. But as routinely as we've raised these same issues, the April hearing was actually the first time since this process started and since we started testifying at board meetings that we felt like the agency started to hear us on at least one of our concerns. We acknowledge that the modified draft released yesterday afternoon initiated important work in narrowing the regulations, especially in removing behavioral advertising, but also in removing AI and the training of ADMT. Initiated, but by no means completed. Because we've had less than 24 hours to review the draft, we're still processing the impact of these modified regs. However, we did start to notice some improvement elsewhere, potentially significant in the cyber audit sections as well, around the very problematic board of director certification requirements, which is a very important issue for our members. At the same time, though, significant work is clearly still needed around other aspects of risk assessments and ADMT as well. On ADMT, we appreciate that this draft reflects the board's decision from April to adopt Alternative 2, an effort to start to narrow and adopt a more streamlined and operable ADMT definition that focuses on technology used for decisions about a consumer rather than the use of virtually all automated technology. However, Alternative 2 is still very problematic. And even if it causes less economic devastation than before, it still causes devastation. As such, in addition to other changes outlined in our letter on opt-out and pre and post-use notice provisions, we do continue to urge you to adopt Alternative 3 instead, as it does fulfill the agency's mandate and it best sets a clear standard that focuses on technology that meets 3 critical elements that most other privacy frameworks that have ADMT provisions also limit application to. Tools that process PI with specific heightened privacy risks, lack any human involvement, and make legal or similarly significant decisions. This shift would be more consistent with the governor's directive in his recent letter, where he urged narrowing the scope of ADMT regulations and emphasized regulating responsibly to avoid unintended consequences and substantial costs that threaten California's dominance in technological innovation. We also argue that the 62% drop in projected economic costs both warrants verification with a full economic analysis and clearly indicates that the nature and importance of these changes and their potential impact on our economic stability and prosperity warrants at least a 45-day comment period. 15 days is not enough time or always appropriate when dealing with such highly technical or complex rules. It's the statutory minimum. We note that the Civil Rights Council recently provided 30 days for modified ADS regulations that reflected a fraction of the scope, complexity, and length of these regulations that we're dealing with here. Lastly, businesses need adequate time to come into compliance. We appreciate the delayed effective dates for ADMT requirements as well as cyber audits and risk assessments. We do hope that you will consider at the very least a January 1st, 2027 date for any remaining provisions that lack a date certain for compliance, though we do still hope for a full 24 months to come into compliance with all regulations. Thank you.
Thank you.
If there are any other members of the public who'd like to speak at this time, raise your hand using Zoom's raised hand feature or by pressing *6 if you're joining us by phone. Again, this is for agenda item number 4. Madam Chair, I'm not seeing any additional hands at this time.
Thank you very much, Ms. Marzian, and my many thanks to the public commenters for their thoughts today. So we do have a motion on the table, and I mentioned that we should return to a potential timeframe for public comment on this round, which the statutory minimum is 15 days. We have had some requests from the public to extend that as well, and I'm hoping that Mr. Laird can give us some information about, or can give us some information about the overall effect on the timeline of that. And also would just emphasize to the public as well that, as I understand it, we can always extend the deadline as we did in response to the wildfires if it seemed like it would be necessary, but obviously it would be better to just pick a time frame and go with it.
Yeah, let's see, can you hear me? Okay. So, as I think is clear to everybody, statutory minimum is 15 days. Obviously, that's what the legislature contemplated when they developed the APA process here. But that said, we can do more. To Mr. Worth's point, for anybody listening today, the text that was made public yesterday is what we are really discussing going out for additional public comment for. So considering folks have noticed as of now that this is what's being considered, I think from a processing staff standpoint, especially considering the board is considering next meeting in July on this topic, if we could conclude public comment by June 2nd, which is a Monday, that would be approximately 30 days from today. Now that said, I think we would not be opening formally public comment until next week, but that would still be in excess of a 21-day period and something I think we could accommodate at the staff level.
I see some nods. Do folks think that seems reasonable? Yes, I quite agree. I do certainly appreciate commenters' notes that they're currently still digesting the draft. So I appreciate staff's willingness, I would say, at a minimum, an obvious ability, given what you accomplished this past month, but we don't want to ask you to do that again, to give people a little bit more time to digest. All right, that makes perfect sense to me. Are there any other further comments from the board before I request the motion? All right. Would you like me to restate the motion, or shall I just ask for a motion as stated? Sure, absolutely. The motion is to direct staff to take all steps necessary to prepare and notice modifications to the text of the proposed regulations for an additional
For a public comment period to close on June 2nd.
for a public period to close on June 2nd, 2025. The modification shall reflect the changes proposed by staff in the written meeting materials, except that staff shall further modify the text in line with today's discussion and the board's discussion today. Sorry, I've now mucked up my motion that I had so clean. May I have that motion?
So moved.
Thank you. May I have a second?
Second.
I have a motion on the table by Mr. Worth and a second from Mr. McTaggart. Ms. Marzian, would you please conduct the roll call vote?
Certainly. Board Member Liebert,
Aye.
Board Member McTaggart,
Aye.
Board Member Nanecki,
Aye.
Board Member Worth,
Aye.
Chair Urban.
Aye.
Madam Chair, you have 5 yeses.
Thank you very much. The motion carries with a vote of 5 to 0. Thank you again very much to the staff for the Herculean effort and the really excellent advice that you have given us today. And I look forward to public comments on the modified text. With that, we will move to agenda item number 5, which is our annual public affairs update, held over from a previous meeting, and that will be presented by Ms. White. Materials for this are in your packet as well. While we are changing the stage, we will take a 5-minute break or so, so people can get a little bit of a pause. All right. All right, wonderful. Thanks, everybody, for letting us take a quick break. And let's proceed with agenda item number 5, Annual Public Affairs Update. Always a highlight. And I've been really excited to see the various messages in lots of different channels over the course of last year. I'm excited to turn it over to our Deputy Director of Public and External Affairs, Ms. Megan White, to give us that update.
Wonderful. Thank you so much, Chair Urban and members of the board. I'm just going to check back with our amazing moderator, Serena, and make sure that you can hear me well. Yes, Ms. Marzian, thank you so much. So on behalf of the Public Affairs team, I am so pleased to present the Annual Public Affairs Update. So I'm going to start off by recapping the past 12 months, and then we'll take a look ahead at the rest of 2025 and moving into 2026. Next slide, please. Okay, so let's take a look back, but at a very high level. And I will go into more details about every single one of these icons that you see in future slides. But first, I just wanted to start with some big broad strokes of the highlights that we've accomplished over the past 12 months since I last gave you an update. First, and one that we're really excited about, and I know you all are as well, we launched our paid media campaign. The paid media campaign started in June of 2024, and it's running through the end of this fiscal year. Hopefully you've seen some of our ads in the wild. You've seen them on billboards, maybe online, maybe you heard them in the radio and much more. We're very excited about this statewide campaign. And of course, more to come, more details within this presentation and more to come with our paid media campaign as well. In addition, we've really strengthened our media relations. So I truly believe that strong relationships with reporters is key. And we are so grateful to the reporters who cover the CPPA. As I'm sure you all can guess, it's complex to cover us, right? I always wonder, how do they feel when they get our beat? It's not the easiest one to cover. And their job is really important. Their job is fair coverage. And our job is to be responsive and provide them the information they need so they can write their stories. In addition to really having strong relationships with existing reporters who cover us, we've also done a tremendous amount of outreach to members of the media who don't regularly cover us. And we've really expanded our press distribution list. So every time we put out a press release, more and more reporters are getting that information. And we want to just continue to grow our media relations. I'm sure as you all have also noticed, we've seen a big uptick in our coverage. And that's really thanks to a lot of the media relations that we've been doing and also more of the press releases we've been putting out. And really that goes back to all the amazing work that everybody here at the agency does. So we're excited to spread the word. Media relations is never ending, it's ongoing. So every year you're going to hear me talk about it. And going on to the next one, outreach. That's another one that is always ongoing. So since my last presentation, I am excited to share we have a huge change to our outreach. We actually have an outreach team. So we have 2 amazing team members who have joined our public affairs division, outreach manager and outreach specialist, and they are starting to really lay the groundwork for our outreach campaign. They developed an outreach plan. They've organized our whole system in terms of garnering outreach. They've reached out to a lot of organizations. And I know you maybe have seen some of our staff members presenting at different conferences. That's all thanks to the hard work of the outreach team. They coordinate all those speaking engagements, do talking points, slide decks. So they're really firing on all cylinders already. And I'm excited for what we're going to be reporting back to you a year from now. But most important to me, those little icons right up there, fully staffed. There's 5 of us, so maybe one isn't as important to me, but the other 4, I'm just so pleased and honored to get to work with these amazing, talented people. Last time I presented to you, Ms. Nicole Cameron was a part of my team. We were a team of 2, and she's the communication manager. But since I presented to you in March, of course, I know you all know Ms. Marzian. She joined our team in April of 2024. In addition, Bryce Alvarez is our communications manager. He joined us in July of 2024. And then our outreach specialist is Melissa Rosser. She joined us in August 2024. So really now we are fully complete, we're fully staffed, and we're really ready to go and hit the ground running. Ms. Marzian, could you advance? Thank you so much. So, hitting more deeply on the paid media campaign, we launched this campaign in June of 2024, and this phase of the campaign is going to wrap up in June of 2025. The goal of our campaign was general awareness of the agency, and the call to action was really get people to visit privacy.ca.gov, our customer-centric website. The campaign theme that we used is exercise your rights, and we did this to remind Californians that they have rights and that they need to exercise them. As you may recall, we did a statewide survey in December of 2023, and we realized that most Californians weren't even aware that there's an agency out there to help them with their privacy rights. And we understand, and I know you do as well, that you have to build trust to build awareness. So as you saw through a lot of these campaigns, it was just a general awareness campaign. We wanted to get our name out there and privacy rights in people's faces, and then also the privacy website. I know everybody is very interested in the budget, so I want to touch on the budget for this really quickly. So as a reminder, this whole campaign that we just did, that we are currently in the process of, that's going to end in June of this year, this is what at previous board meetings we've referred to as Contract 1 of the Media Buy campaign. It was executed via our public relations, media, and media buy consultant, Census, and they also do the creative as well. The budget for this campaign was $7.9 million. That money was mostly spent on media buys, but there was a small amount of it that was used for the creative development of the campaign. But as I mentioned at my last presentation, a lot of the creative development was done in-house by Ms. Cameron. So we were able to save some money there and use a lot of it for the media buy. We also used this money from that contract to do that statewide survey that I mentioned earlier, along with an allocation for translation services. And in addition, they also helped with some event services. So those stakeholder sessions that we did in the spring of last year, we used the contract for that as well. And obviously this was all in the contract. You know, there was an allocation for media buy and then some smaller allocations for these other things. So this contract, Contract 1, is almost complete. That will be totally done in June when we do our final media buys. There's nothing, they're just implementing our media buy plan. So we just have a little bit left for that phase of the plan. Next slide, please. Okay, so what did we accomplish with all of this? Well, I'm pleased to say that we got 665.5 million impressions. So that's people who saw our ads with the money that we spent in the media buy. So if you think about it, I just saw the governor put out a press release today. California has 39.5 million Californians, so a small uptick over the previous year. So if you think about that and you do the quick math there, about 17 views per person. And so that's just eyeballs on this, right? So that's a good statewide campaign. We really were able to get in front of every single Californian if you think about it that way. And how did we do this? Well, the campaign tactics that we used were online, streaming audio and podcast, radio, print. In addition, you know, when you get your e-newsletter from like different publications, there's the banner ads there, we were there. And then a lot of out of home. So that's your billboards, digital billboards, ads in airports, things along those lines. And this whole media buy was constructed with assistance from our consultant Census, staff's input, in addition to the great guidance that we received from Board Member Worth and Board Member McTaggart. So again, our billboards ranged in various sizes. We were also on bus tails, as you can see here. And then also I'd like to direct your attention to the two photos in the lower right-hand corner. That's a great example of how we were able to get into local communities. So we used, Census provided us with a subcontractor that actually goes into local grocery stores, local mini marts, pharmacies, and they put up our banner, and then they also put up brochures. This was done in English and Spanish. It's a really great paid advertising technique that also has a real grassroots approach to it as well to get the information in front of the diverse members of the state. So print ads were also done in numerous languages too. So we did a huge print ad campaign, and we didn't just do it in English, Spanish, Chinese, Korean, Filipino, Punjabi, Farsi. That's just a few of the languages that we produced these ads in. So really tried to reach every Californian where they are. Next slide, please. All right. In addition, we put out our first annual report. So this captures the highlights of the agency's work from inception of the agency through the close of 2024. This report was really well written and absolutely beautifully laid out, in my personal opinion. But I can't take credit for it because it was written by Mr. Alvarez and designed by Ms. Cameron. So they really put a lot of time and consideration. And as you'll see, there were helpful sections including at a glance. So that's one of the ones we have there. We wanted to make it a real quick look. I know a lot of people don't love reading a good annual report, so we tried to make it as user-friendly as possible. So you saw the at a glance with some big numbers, highlighting what we've done. You also saw the agency milestones. In addition, each division had their own section where they got to highlight what they accomplished. And then we also had highlights from our strategic plan. And as the name implies, we've already started on the annual report that's going to cover all the work we've done in 2025 and look for that to come out in the first quarter of 2026. Next slide, please. So in addition, as I mentioned, we've gotten a lot of media coverage thanks to the hard work by the various members of our agency. Just for a little recap, in 2024, we put up 21 press releases. So far in 2025, we've put out 10. So if you think about it, we're really 4 months into the year. We're clearly already outpacing what we did in 2024. That said, we don't put out press releases just to put out press releases. Every time there's news that we want to announce to the public, we discuss it at the executive team level, and my team also discusses it. Not all news needs a whole bunch of media blasts and everything like that. Some news needs extra attention. So we look at everyone as case specific, and I create a communication plan around every single thing that we're trying to communicate to the public so we can do it as effectively as possible. So I really do feel like we are getting a lot of strong coverage thanks to our media relation efforts. Next slide, please. Moving on to social media. So we continue to use various social media platforms to engage and educate Californians about their privacy rights. As you know, we have some existing social media channels. We have X, formerly known as Twitter, LinkedIn, and YouTube. And we were able to grow those 3 channels by 22%. In addition, we launched 3 new platforms this year: Blue Sky, Instagram, and Facebook. Now, don't laugh that we're just now getting onto Facebook and Instagram. We are a relatively new agency, so of course, we didn't have one until recently, but we are on all of those channels now. And we are going to continue to post and use them as great ways to get in front of Californians. Next slide, please. In addition, we really upgraded the look of our social media posts. So you've noticed now all of our posts have a consistent look and feel. We also try to explain some complex things in really easy ways for most Californians to understand. And as you know, we have a variety of news coming out of the agency, from tips to bills. We try to make sure that everything is conveyed in a way that's easy to understand. Next slide, please. So the privacy.ca.gov website. As you probably know, the agency actually has 2 websites, cppa.ca.gov and then privacy.ca.gov. cppa.ca.gov is a lot of the agency work. So you're going to see the board materials up there and things along those lines. As you all know, privacy.ca.gov is really consumer facing, where we want to provide really helpful information to the average Californian. So since June of 2024, we've had more than 1,100 visitors to the privacy website. For reference, last year when I presented to you in March, we had approximately 400 people who had visited the privacy website. So as you can see from this chart, we did launch in January. I think a lot of those little small bubbles were internal team members. And then we really took off once the paid media campaign took off. And I just think that that's a really great example of how money is, yes, board member Worth. Oh. Sorry, go ahead.
No, just those spikes, are those tied to press releases, you think?
I'm curious about that as well.
Sure, of course. They're actually tied to tactics with the media buy campaign. So if you remember when we showed you the media buy campaign, and we have some things that are consistent throughout the year, those low hums, and then we do spikes where we do radio spots would come online or newsletters. I wish it was all due to our press releases, but I can't take credit for that. So, but it really did give us an amazing boost to get our word out to as many people as possible. Next slide, please. All right. And so who is visiting these websites? We're not doing, of course, tracking on our website outside of total visitors and locations. And so we're really pleased to see that the top 5 regions are all coming from major metropolitan areas within the state. I think it also gives us a really good guidepost of where we need to do some more outreach, because clearly you're not seeing Fresno or any other Central Valley cities there. But at the same time, I am pleased to see that this website's really being used by large population areas throughout the state. Next slide, please. Oh, and I do want to say one additional thing about the website in terms of viewership. We are growing partnerships throughout the state with nonprofits and encouraging them to list the privacy.ca.gov website on their website as a resource. It's so important to get in with community groups. And so our amazing outreach team is leading that effort, reaching out to all kinds of stakeholders to see if they would list our website. So far, more than a dozen organizations have agreed to do so, and we just are going to continue to reach out and get more and more to include our website on their website. Okay, moving on to the blog. As you've noticed, we have added things to the privacy website. One of the things that we've added is a blog, and we're going to continue to do regular posts to the blog. Every time we do a post, we promote it on social media channels. And in addition, we've added some educational resources. This includes a Know Your Rights brochure, a video on the rulemaking process. We wanted to, we have so much rulemaking going on. We wanted to make sure that it was very easy for the public to understand how to get involved. And we also have information on the data broker registry. That said, I know we need a lot more information on the privacy website, and that is one of the key priorities that myself and my team are going to be working on over the next 12 months. So you're going to see a lot more information popping up by the time I'm back to talk to you next year. Next slide, please. Okay, speaking engagements. So we've already dramatically increased our speaking engagements in 2025 from the previous year. So in 2024, we spoke at 30 events. So far in 2025, we presented at 18 events, and we have many more calendared. So again, that's only 4 months, and we already are doing 18. The public affairs team coordinates these events, as I mentioned earlier, with talking points and slide decks. And these events, I'm not including all the other events that my team oversees, including meetings such as this, stakeholder sessions, public comment hearings, things along those lines. So those are just getting out into the community. Next slide, please. Internal communications also falls under my team. And I really feel passionate about internal communications. Organizational culture is so important. And we have a team that's diverse throughout the state. And so we want to make sure that to improve employee retention, engagement, and cross-divisional collaboration, that we have really strong presence in terms of internal communications. So far, we've implemented something that we call CPPA Insights, which is a monthly webinar. For our staff, they all get together and we talk about all different kinds of topics. Sometimes we have a guest presenter speak about a privacy issue. This month, we're going to have CalPERS come and talk about pension benefits. So it ranges in terms of like employee interest and then also employee education. We also have an internal monthly newsletter that we put out. So every month, our team gets an email put out by my team, letting them know about everything that's going on at the state and at the agency. We also have started an intranet. So any day, people can go to the intranet and they'll see a little article from my team. There's not a new one every day, but there's at least one a week where we're letting them know about something new that's going on. So we're really just trying to improve. We have a great culture at the agency. We're trying to continue that culture and get us all more engaged in talking to one another. And I also work very closely with our admin team in terms of making sure that our intranet also has all of our policies and things like that to make it really easy for staff. In addition, you may have noticed that we've upgraded some of our visual things. We all have those beautiful new backgrounds that we use for meetings. Our slide decks are all customized and standardized, but then also give the staff the ability to customize different slides based on what they're presenting. So we're just trying to make things really easy for our team members so they can focus on the hard work they're doing and not worry about how do I put together a slide deck. So now looking ahead, let's pivot to what's to come. Next slide, please. Okay, so I see, and I'm focusing in on paid media campaign. I see our campaign as having 2 phases. I see us moving from who we are to how we are here for you. So phase 1 is what we're wrapping up in June. And since we are such a new agency, we wanted to start with some really basic outreach, general awareness. And the messaging is focused on letting Californians know that there is an agency dedicated to protecting their privacy rights. I would consider this phase 1 of our outreach. Now we're really excited to pivot to phase 2, focusing on how the CPPA is here to help the average Californian protect their privacy in whatever way that feels right for them. That's one of the most significant things about the CCPA is it's your personal information. You get to make the choices on what's right for you. And so our goal with phase 2 of the campaign is to provide that information in plain language and through various communication channels so Californians can better understand how they have control over who they share their personal information with, and much more. So how are we going to do that? That's going to be through a new media buy. Next slide, please. As you may remember from previous board meeting updates, we now have 2 active contracts. So I am not referencing contract 1, which is almost complete. We have about $300,000 left of a media buy there, let's say that. So I'm focusing on what I'll call contract 2 and 3. One of these contracts is for $2 million, and that's focused on creative development. The other contract is for $7.9 million, and that is mostly for a media buy with a small allocation for creative services, research, because we'd like to do another research project later this year to see how well we're doing in terms of reaching the average Californians. We can also use that contract a little bit for translation services and event support. This contract was won by Census, who we worked with on the prior campaign. It went through an RFP process, and they were the successful bidder. So we have one consultant who's managing all these contracts. Both of these contracts, all of these contracts really, but I'm referencing contract 2 and 3 here. These were funded through one-time funds and are set to expire in June 2026 and July 2026. So that $2 million for creative development expires in June of 2026, and the media buy expires in July of 2026. So we have partnered with Census to develop a media buy strategy, and that media buy strategy is going to take off as soon as contract 1, so the current media buy strategy goes away. Then we're going right in June of 2025 with the second media strategy, and that will run for 12 months and wrap up at the end of the fiscal year of 2026. This campaign takes the tactics that worked well from the previous 12 months and also incorporates 2 new 30-second spots. So at a very high level, we'll continue to focus on brand awareness. We're also going to really promote drop once we get into 2026 with this media buy dollars. And we're going to continue to work with out-of-home vendors that help us reach diverse communities. So as you look at these little icons here, those 30-second spots, you're going to start to see them on TV. In addition, we're going to roll them out in out-of-home venues. So you'll be at the movie theaters and you'll see our ad come on right before your movie. Maybe you're pumping your gas, those little videos you get when you're pumping your gas, you're going to see our ad there too. We're also going to continue to be out in communities. So we're still going to use the subcontractor to have all of the brochures and banners out at various community stores. And in addition, we're going to continue our billboards, digital billboards, static billboards, along with radio, so much more. Okay, but that's just kind of a big broad stroke there. All right, next slide, please. Okay, so this kicks off our new creative campaign is going to kick off this summer. We're already in the planning stages, but when we go into that new media buy, we're going to roll out some new creative. So for the out of home, as I mentioned, we have these videos. We just went down and we shot them in February and March of this year. So you're going to see 2 beautiful videos that are going to be out there. And in addition, we're going to refresh our creative. So we're going to start to, sorry, go ahead, board member Lute. So the theme for the video, the first one we call Life on Display. And I'm so excited to share it with you. We're in the final editings of these videos, so I will definitely be sharing them with the board as soon as they're ready to go. I bet you 3 weeks from now, we'll have them. So Life on Display, this is the amazing actress we had doing it, and she's basically in an art gallery, and she's like looking at all these beautiful pictures of her family, and she's like, oh, this is so nice. And then all the deep in, and they start stamping sold on all of her little mementos, like a picture of her family, keys to her home, all these different things. And then all of a sudden, you get a tight shot of her, and she's on the privacy.ca.gov website. And she's relieved because she knows how to do this. And then Serena or Ms. Marzian, do you mind advancing to the next slide? This next slide we call obstacles. So the 2 spots. So this is our male actor who is in the other 30-second spot. And this ad portrays how it can be really confusing to understand how to opt out. So it really is a little bit of a dark pattern sort of play with this one, where he's in an office building and he's like trying to get to the office of privacy choices and he can't figure out, and they've moved the offices and he's running up and down these stairs. And then finally he's just so irritated and he's like, why is this so hard? And then you pan to him in his office, or in his bachelor pad, as they were saying to me, and he's on his laptop and he's on the privacy.ca.gov website and he's learning how to better protect his rights. So both of these 30-second spots are really driving Californians to the privacy website so they can get more information, because as you know, our laws are complex. Can't convey all that in a 30-second spot and keep it engaging while people are waiting for their favorite Disney movie to come on. So we tried to make it really engaging and relevant to the average Californian.
So I want to follow up on that because I wasn't that keen on privacy as a team sport as a big message.
Sure.
Yeah, the microphone problem. Because as we've talked about, we keep telling people that they've got to do stuff. Right? And we want to make this easy for them. I'm excited to hear about this idea of driving traffic to the website, but that really underscores the need for that website to be really consumer friendly. I don't think we've hit that mark yet. So it sounded like there's a process by the agency and staff now to really evaluate how to update that website to make it as user friendly as possible, so that if we actually are successful now with these campaigns and driving people to it, there's a really quick and easy way for them to get the information they need to protect themselves.
Yeah, I could not agree more. And that's the whole point, because there are so many complexities to the law. And so they do need to go to the privacy website to learn more, and we do need to provide more information. So I will let you know that we have a clear path forward on this. I'm working very closely with our executive director, Mr. Kemp, to make it happen.
Great, okay.
Should we let Ms. White finish?
I'm really close. So next slide, please. In fact, we'll just wrap it up here. The other thing you're going to really start to see from us this year is getting out into communities. So we've got a real focus on reaching out to community-based organizations. We want to go throughout the state and make these presentations in front of people. People connect with people. And, you know, we can seem like this state agency that's sort of up here in Sacramento doing all kinds of things. And the only way to break that is to really get on the road and start talking to people. And so that is a big focus that we have for the next 12 months. We're going to do this through forming more partnerships with community groups, because they're trusted within their community. And when we make those relationships and they invite us to come speak to them, as it's starting to happen right now. So not just the privacy conferences with lawyers, those are important, but where my team needs to be is out there talking to the average Californian and giving presentations to them. We're also going to be growing our social media channels and, of course, growing that privacy website. So honestly, that was the end of my presentation. So I'm ready to pivot to questions.
Wonderful. Thank you so much, Ms. White. This is incredibly impressive. The theme of our meetings is so often small teams punching above their weight, and this is one more in that general family. Mr. McTaggart?
Yeah, this is really awesome work, so well done. It's a lot of work. One question I had, so DROP is not fully kind of, is it all way up to speed? Are we ready for prime time? Kind of not right. So is there a way to back end some of the spending so that we can make sure that as we spend for that kind of thing, that we have the DROP, ready to go? Because it'd be nice if people, I know we're not necessarily only advertising about DROP, but I'm just kind of wondering, do you have some flexibility? That's one question. And then can you just refresh the 2 and the 7.9? That's already allocated. That's in government world. That's not like a decision for us to spend. That's already been done, right?
That has already been done. Yeah, it was a one-time expenditure and we had to use it on this stuff. So yes. In terms of your drop question, yes. In fact, just on Friday, so less than a week ago, we were down in LA meeting with our consultants, and we talked about this very thing. Mr. Kemp joined us. Also, Ms. Garcia was there as well. And we discussed, should we move some of these media buy dollars towards the spring of 2026? And I felt like it was more important to get the brand awareness out and not necessarily take 70% of our media buy dollars and move them to the spring to promote drop. Also because, as you all know, the website will go live in January for people to sign up for drop, but data brokers won't be accessing it until August. So people aren't going to see their information deleted until later in 2026. So there's also a concern if you get all these people to sign up and then they don't see any change. Yeah. So that's why we were like, okay, what we're going to do is let's talk about it. So we all talked about it. We brainstormed. And really what the creative consultant said is that drop sells itself. People are looking for a solution to get their emails deleted from data brokers, the people who would like to do that. And what we need to do is build trust and awareness around the agency. So when they do go to use drop, they trust us, they know us. Because I will say, when you get out there and you talk to community groups, they're not super trusting of government. So the idea that they're gonna give us their email address, it's kind of an ask, right? And so if I just hit them hard with drop, but they don't know who I am, they're not going to use it. And so it is a little bit more strategic in terms of just a long-term brand awareness campaign, also because we won't have these funds again, right? I mean, unless something happens and we get additional monies, but this is it. So what you're going to see is these 2 30-second ads, which are going to take up a big chunk of the media buy percentage, right? Because we're not just going to have them on TVs they'll be on connected TVs. So you see a little QR code and you're going to be able to scan it and go to the privacy website. You'll also see those running in movie theaters, at gas stations, things along those lines. So we're going to do all those things. And then once we get to the spring of 2026, we're going to pivot our creative. So Exercise Your Rights is going away. We're going to have new creative that comes out the summer and runs until, say, February 2026. And then February 2026, you're going to see new radio spots, new creative, all promoting drop. So it's a year-long campaign, because we are in this for the long run, unlike, say, an election campaign where we just have to hit everybody hard so we get them to the voter booth. We are actually trying to build brand awareness of an agency. So it's a little bit of a different strategy there. It's what Census recommended and our team agreed.
Okay, hopefully you feel like you have the flexibility to adjust that, and it's not something, I don't feel we should be necessarily saying, put it in January, put it in December. I just kind of wanted to bring it up.
Yeah, no, I appreciate it. Mr. Kemp obviously is very passionate about drop. So we've had numerous conversations about how we can get out there and get the word out.
Thank you, Mr. McTaggart, and thank you, Ms. White, for the explanation. I fully agree with Mr. McTaggart that this is, the details of this are for the pros, but I also do want to highlight that drop is going to be an incredible step forward, and it is simple to explain. And we should capitalize on that by thinking carefully about how to allocate the messaging on drop specifically compared to the continuing foundation building that started with the survey, which again was really important in order to understand how little awareness there was out there, which some of my own academic research was on how people understood their privacy interests and how they understood their privacy rights. It's just a long-standing challenge. And I think that it's just been really wonderful to see how much more people are aware of the agency and they are aware that they have rights in California. So continuing to build on that seems crucial to me. We don't want to lose that momentum in the cacophony of the political landscape and in the cacophony of the marketplace for people. I know we always tell you, prioritize everything. But I do want to highlight the last slide in the community outreach, connecting that to your efforts with regards to reaching different language communities and making sure that you're working with community organizations and nonprofits in order to get the word out. That to me seems absolutely critical. It is critical for the reason that you stated, Ms. White. that we need to be able to have trust with our communities, which means that, of course, they need to understand who we are and why they should trust us, and we need to understand what their needs are. And that is not a short-term endeavor. That's a long-term endeavor, and that's an endeavor that goes through community partners. So I really appreciate that that is a very careful part of the overall messaging work that you're doing, and just want to underline my support for that, and taking Mr. McTaggart's point absolutely to heart. Not telling you what to do or how to spend the money, but that is a piece that is near and dear to my heart. So thank you very much for that. Other comments or questions? Dr. Nunke?
Yeah, I have a question about which types of media placement, media buys do you think were the most effective at driving traffic to the website?
Oh, yeah, that's a really good question. I know we tried to like figure out where the big bumps were. We got a lot of bumps when we would do newspapers, when we would do e-newsletters, and you'd have the banner right up top. That was where they saw a really big jump. It's a little harder because we've had these billboards running so long, and you can't say that somebody saw the billboard. You know what I mean? I can tell you, like, okay, if the Sacramento Bee had the banner ad there, and you click on that banner ad, I can tell you that's where that came from. So I can't necessarily say like, oh, that so many people drove by the billboard and then they went to the privacy website, because I don't have a way to tie those two things. But they did say like e-newsletters were very, very popular. Getting on social media platforms, there were certain ones that performed really, really well. I don't know if I should share which ones outperformed others, but a lot of social media platforms we saw a nice big jump there, along with radio, especially NPR really played well.
Yes, Mr. Liebert.
I just want to build on my fellow board members' questions about the drop process. Just on the financial side, if I understand it correctly, you are suggesting that there will be sufficient funding later on in the year that will be available for the drop process and getting that word out. It sounds like you feel like you have that flexibility, right?
Yes, I will have the media dollars to spend from, say, I mean, I have them right now, hypothetically, but I don't have drop system. So I will pivot our creative in February of 2026, but then I have to spend all those funds by the end of the fiscal year. So you're not going to see, unless, you know, we get additional funds from some other way, you're not going to see advertising around drop once we hit the, you know, August really of 2026.
So what you're saying is we need to complete those regulations.
It helps. And I know Mr. Laird and his amazing team are busy with drop. So I have total confidence, but yes, we're not going to have funds to advertise because I can't move these funds around.
Thank you.
And Ms. Garcia made a great point. I'm not going to have paid media advertising dollars to do this, but that doesn't change our approach. I'm used to being at government agencies where there's no media buy, right? So it's all grassroots earned media where you're going out, you're talking to people, you're doing press releases, I'm pitching media, social media. So I'm going to wind up going back to more of my PR roots and getting eyeballs on drop in a more not traditional way, but you know what I mean, through more traditional methods than what most government agencies have, like a big ad campaign.
So that, sorry, but that part I'm a little confused about. So I think what you were pointing out is there actually won't be sufficient money for media buys, et cetera, for drop that's currently scheduled, right? Because drop isn't there yet. Is that what you're saying?
Sorry if I'm not being clear. So basically the money that I have to spend on advertising is going to be gone by June of 2026. So I can run drop ads until that contract is over. And then once that contract's over, I'm not going to be able to do paid advertising around drop. So we're going to rely on our team, your public affairs team, and we are going to do ways to get in front of the public. So it's pitching the media, blogs, getting on podcasts, all of those more traditional earned media routes. But no, there's no media dollars allocated for a media buy for drop that I'm going to be able to take into the fall of 2026.
So basically, we need to get the regulations done. So we have the timeline as we expect for data brokers to need to pull the data.
Right.
So that it is an effective tool for consumers We don't want to be advertising something that doesn't work for people yet. And then we could do awareness.
Right.
We could do awareness,
Right.
and then follow up with sort of in a more grassroots fashion, with people, because it's pretty straightforward again to understand. People can go to the website and figure out how to, it'll be pretty easy to understand how to do it, but we want to have it ready.
Yeah.
So that initial sort of identification of the tool is available. Okay.
Yeah, I just think we're going to want to have bucks for media buys to get the word out in a big way about what may be one of our most successful programs ever for this agency.
Right.
So not just relying on these important other tools that we have, but thinking about having the funds for media buys to do it as well.
Yeah, I just can't hold back any of this money. Yeah, so if somebody wants to find another pot of money for advertising, I'd be happy to take it. But yeah, Ms. Garcia.
No, can you hear me? The only thing I wanted to add is that, yes, this is halfway through the next fiscal year, and the legislature and the governor are, nearing close budget deadlines, but nothing precludes us in the future for doing another budget change proposal to request additional dollars for this if this is a priority for the board.
Got it. That's what I was thinking.
Thank you. Additional questions or comments? Is there public comment on this item, Ms. Marzian?
This is for agenda item number 5, public affairs update. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing star 9 if you're joining us by phone. This is for agenda item number 5, annual public affairs update. Madam Chair, I'm not seeing any hands raised at this time.
Thank you very much, Ms. Marzian. Thank you again, Ms. White. This is incredibly impressive. And on behalf of the board, I thank you and your team for your excellent and very skillful efforts here in order for the public to be able to become aware that we are a resource for them. With that, we will move on to agenda item number 6, which is the item for public comment on items not on the agenda. As I mentioned at the top of the meeting, actually, you know what I'm going to do? Apologies, everybody. I'm going to skip over this one for now and move to future agenda items, which is agenda item number 7. This is our item to discuss future agenda items. The board is unable to discuss the substance of any items, but only consider them for inclusion on a future agenda and talk about some logistics. And the reason why I'm bringing this up is because I understand that we should have a short discussion about which of the July dates that we put on the table last meeting, we should plan on if staff are ready to confirm that with us.
Yes, absolutely. So I believe there was 3 or even possibly 4 dates that were considered at our last meeting for July, but based on the fact that we are now advancing these draft regulations to public comment in the interim, taking a later date in that time would be preferred. So staff would recommend Thursday, July 24th as the date for the next board meeting.
Thursday, not Friday?
Thursday, not Friday.
Okay. For some reason, I have both of those as possibilities.
We held both.
Okay.
Yes.
Okay.
And I suppose I should make the caveat, if there's enough the board thinks it would like to do a 2-day meeting, of course, we could keep both
Okay.
open. But
Thursday sounds great.
Thursday, July 24th? Going once, going twice. All right, we confirm Thursday, July 24th. That'll be in Sacramento, as I understand it. Well, I'll be well, those of us from other areas of the state will be enjoying the true summer weather. Indeed. In terms of future agenda items, we've had our report out on the public awareness work. So thank you again, Ms. White, for that. We will have an update on staffing and administrative procedures in a future board meeting, just so that I can help us keep track of the items that are on the running agenda for appropriate inclusion into an agenda when it's the right time, is GDPR adequacy questions, which Mr. McTaggart has mentioned, and we may have a briefing from European experts, given lots of changes in the political landscape. Of course, staff will let us know what is the best approach to that. We will hear about comments on the data broker rulemaking when those are ready. We, of course, will have comments on the modified language that we approved to go into the second comment period today. We will discuss, or we will hear about the chief privacy auditor position when it's correct time for that. We did hold our general discussion of regulations priorities, which is on the annual regularized calendar for May, actually earlier, I think, until the end of the year, because we do have two substantial packages underway. But I will note that I still have on my list that Mr. McTaggart is interested in implementing the right to delete in terms of partial deletion, and just remind board members that at any time you can check in with the legal division and offer suggestions that you would like to go on the list for that discussion. Are there additional board member agenda items? Yes, Mr. Worth.
I got one, Dad. I think when you listen to all the comments we get, one thing you're going to learn is we can't please everybody, but what you hear a lot of is the cost of small businesses. And I just was doing some quick searching. We've got 4.15 million small businesses in California. And our math shows about 7,984 being impacted. That's revenues of 50 million and below. So it's a very small subset of the small business that'll be impacted by these costs. But I think better than getting on the fly an economist, one thing about economists is they're historically incorrect. So one thing I'd like to do is maybe if we can engage, and if I could help, I'll certainly do this, but engage an accounting firm who's going to be doing this work, because usually these are add-on services. I don't think the costs we got today were accurate when you already have a full audit going on. So if we could, just help give some people better perspective of the real costs here, I think that'd be helpful for folks' concerns.
Thank you, Mr. Ward. So to be sure that I understand the request, so an analysis with an appropriate expert of the scope of small businesses covered by the statute and by regulations.
The cost of that subset, yeah.
Yeah, okay. I would be interested in just understanding the subset with a little bit more concreteness. The numbers are in the statute, the numbers are in the regulations, but being able to match that up with how much of the business economy we're talking about in California would be really beneficial. So I second that request. Any additional? All right. Oh, yes, Mr. Laird.
I'll just note the one other thing on our regularized calendar is an enforcement update that we would anticipate.
Oh, my apologies. My apologies. And the enforcement update, do we expect that in July, or do we expect that in the following meeting?
We'll assess. We'd like to do it in July, but
right.
There's a lot probably going on in July between the two rulemakings. So we'll
Indeed,
come
and we may, of course, need to respond to questions from the legislature or anything that comes up during the legislative session. Okay, thank you. Ms. Marzian, is there public comment on this item?
This is for agenda item number 7, future agenda items. If you'd like to make a public comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 7. Madam Chair, I'm not seeing any hands raised at this time.
Thank you very much, Ms. Marzian. With that, I will recall agenda item number 6, which is our item for public comment on items not on the agenda. This is the one item in which members of the public can provide comments on things that were not on our agenda for today. As a reminder, or for those of you who are new to our meetings, the board may not discuss or act on any matter raised during this particular public comment section, except to consider again whether to place the matter on the agenda for a future meeting. I also have a note before we begin taking comments that the agency is in the midst of a formal rulemaking process for the rulemaking package concerning the delete request and opt-out platform. That's the drop regulations and the drop tool that we've been talking about today without saying what the acronym stands for, which is very bad of me. I always insist usually that people spell it out, but that is what it is. Those regulations are open for public comment at the moment in the formal rulemaking process. And so I remind everyone that today's board meeting is not a hearing for receiving public comment on those draft regulations. And as mentioned earlier, the board will consider comments after they are collected. The initial comment for that draft regulation package will remain open until Tuesday, June 10th of 2025. And with that, Ms. Marzian, is there any public comment on items not on the agenda?
All right, this is for agenda item number 6, items not on the agenda. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing star 9 if you're joining us by phone. This is for agenda item number 6. Madam Chair, I'm not seeing any hands raised at this time.
Thank you very much, Ms. Marzian. Our final agenda item is item number 9, adjournment. I would like to thank everyone, the board members, staff, and members of the public for their many contributions to the meeting and to the board's work. I'd like to especially again thank staff for the above and beyond effort to brief us appropriately for discussing the regulations that we decided to put into the next round of formal rulemaking today, and to the board for its careful consideration of some pretty detailed changes to those regulations as we continue to work towards this goal on behalf of the members of the state of California. May I have a motion to adjourn the meeting?
So moved.
Thank you. I have a motion from Mr. Wirth. Do I have a second?
Absolutely.
Thank you. I have a motion from Mr. Wirth and a second from Mr. Liebert. Ms. Marzian, could you please conduct the roll call vote?
Yes, this is the motion is to adjourn. Board Member Liebert,
Aye.
Board Member McTaggart, Board Member Nanecki,
Aye.
Board Member Wirth,
Aye.
Chair Urban.
Aye.
Madam Chair, you have 4 voting yes and 1 absent.
Thank you very much, Ms. Marzian. The motion carries with a vote of 4-0, and this meeting of the California Privacy Protection Agency Board stands adjourned.